On that side, we'll take yes. Yes.
এই দিক থেকে
You mentioned for admission with the
Admission appeal. Yes.
But application in connection with the first
Application
miscellaneous appeal, Lord, it was directed to appear today. Lord, the matter is not appearing, Lord. I'm just handing over.
Yes.
My lord, I am appearing for the appellant in this matter, my lord. What Mr. Mukherjee has submitted, my lord. My lord, today I am not carrying the brief, my lord, and tomorrow I have personal difficulty. If my lord kindly
Will it
consider that,
appear in the list? Let us see.
my lord.
Permitted to mention this application in connection
Application, yes, sir.
tribunal.
Yes, yes, whatever. Application solved.
Dismiss what you are in final order.
Please.
This matter pertains to land.
Hand over.
First miscellaneous appeal, my lord.
First miscellaneous appeal, very well. Hand over. Let it come in the list. First miscellaneous appeal টা অনিন্দিতা সোমবার দেবেন। নিয়ে নিন, সোমবার দেবেন। এখন order 41 গুলো first miscellaneous appeal হলে সব সোমবার।
But my lord, kindly to mention item numbers 10 to 12 of my lord's list. But I'm led by Mr. Abrojit Mitra, my lord. He is
Led by Mr.
Abrojit Mitra, my lord. He is unwell, my lord. He has not come to court. So, my lord, if it could stand over for the week, my lord. These are assigned matters.
10 to 12.
10 to 12 these are assigned.
My lord, I am appearing for the respondent, my lord.
You have no objection, then we'll adjourn it.
My lord, your lordship can adjourn it, my lord. We can proceed in the lower court, my lord, before the writ court, my lord. There is no stay, my lord.
He was there yesterday also when the matter was called.
My lord, there is no
today
stay,
he
my lord.
was-
So let this not be treated as that there is a stay, my lord. On the last
Sir,
petition
Gupta,
also,
let
your
it be-
lordship was also.
If they say that if you
There
agree
is
to
a stay which against which we have come up. There is a stay in the lower court.
very well.
My lord,
So
the writ court was supposed to hear it out, my lord. The stay is on an order
not-
passed by the writ court where we have made an application for
We have
recalling.
not
So
done
there is
the
a stay.
submission.
you have no difficulty, Mr. Gupta, if the matter is adjourned simply sit then no.
Simply said
Yes,
adjournment.
yes, I don't have a problem, my lord.
Adjourn
Let
till
it be
next,
adjourned simply.
next Tuesday.
Next Tuesday.
Very grateful, my lord.
10 to 12. 10 to 12. Adjourn till next
Grateful, my lord.
And Mr. Rai is taking advantage of his birthday. my lord.
office.
Birthday.
Mr. Roy's
That's the
birthday.
last
Happy
thing that
birthday.
can happen, my lord.
Happy birthday. Wish you a very happy
Very
birthday.
grateful, my lord. Very grateful, my lord.
You share your birthday with greats like Justice Vishwajit Basu.
I'm very grateful, my lord.
Yes. So yes. Yes. Can't hear you. Admission, yes.
WPLRT in for inclusion.
Yes, yes.
Inclusion for appeal.
Appeal. What appeal?
FAT
Land.
107.
FAT, we don't have determination anymore.
Okay. Sorry, very much.
Well, inclusion for review application, you can see your lordship's judge.
Single bench or division?
Division bench, your lordship's.
Your Honor, this is a matter for inclusion in
Use the mic. You have the mic before you.
Your Honor, this is a matter for inclusion in the daily list.
Matter. Hearing or
Committee number 607 of 2019.
we're not interested in the number. What is the stage of the appeal?
Your Honor, the appellant here, I'll just take your
Is
brief time.
it for hearing or an application or
It's
for
an application, Your Honor.
Lordship, I am mentioning
Much
the
obliged.
matter for correction. Lordship, in the order, Lordship,
Yes.
there's the name of the advocate.
Yes, any other mentioning?
May I also mention the matter for the group one magnanimous appeal.
Group 5.
Group one.
Group 1 is hand it to. We will have nothing else to do. Yes, call on up.
My lord, I'm appearing on.
We are reading the conclusion portion. It's a bit longish, but we are reading it so that it's clear.
I
In view of the
appeal
above-
for the appellant virtually, my lord.
Yes, yes. In view of the above, it is an inevitable conclusion that the suit is not barred by any other law than Section 80 of the Code of Civil Procedure. Although the learned trial judge in the impugned deemed degree had rejected the appellant's application for withdrawal of the suit with leave to file afresh, the said findings and observations were set aside by the revisional court in CO number such and such, thus keeping it open for the trial court to pass appropriate orders in connection with the said application afresh. Hence, there are two options open to the trial court in view of our above observations: to reject the plaint only on the ground of Section 80 of the Code, or to permit withdrawal of the suit with leave to sue afresh to cure the technical defect under Section 80 of the Code. We are, however, aware of our constraints as an appellate court sitting in judgment over a deemed decree and not being in season of the application under Order 23 Rules 1 and 2. Order 7 Rule 13 of the Code in any event permits a fresh suit to be filed on the self-same cause of action, does not debar the same merely due to rejection of the plaint on a technical ground. Thus, the effect would be similar whether the application of the plaintiffs under 23(1) of the Code is allowed or plaint is rejected only on the ground of Section 80 of the Code. Accordingly, FAT 513 of 2019 is allowed in part thereby setting aside the findings of the learned trial judge and modifying the impugned judgment and decree dated such and such, thereby rejecting the plaint of the suit under Order 7 Rule 11 of the Code of Civil Procedure only on the ground of non-compliance of Section 80 of the Code. It is made clear that all the other grounds on which the plaint was sought to be rejected are hereby turned down and set aside. Nothing in this judgment shall preclude the present appellants to sue afresh on the self-same cause of action upon due compliance of Section 80 of the Code. Consequentially, the appellant's application under Order 23, Rule 1 of the Code stands disposed of as infructuous, no orders to cost. Pending applications are disposed of accordingly. Interim orders, if any, stand vacated.
Grateful, my lord.
Thanks.
My lord, Mr. Bachwat was addressing your lordship.
I'm for the
Yes.
appellant.
Unwell today, so is Mr. Abrojit Mitra. So, my lord, may the matter appear after my lord, next week, my lord.
If they don't object,
I do not object, your lordship.
you are for the appellant.
I'm for the appellant.
No, I'm for the
I'm- I'm for the appellant, your lordship.
I am for the
The
response.
respondent is asking for time.
Yes.
Which respondent?
Only one respondent
one,
is there,
one,
your
one.
lordship. We had
One.
completed our submissions. They
Oh,
had
right.
commenced their
I was
submissions
arguing, my
with
lord.
the
Mr.
trademark
Bachwat was-
matter, my lord, with regards to
Sir, may
coconut
it be
oil.
fixed on 19 if possible.
19.
12th.
My lord,
don't have any-
12th, my lord.
12th.
Instead of 19th, I'm being instructed.
12th. then.
12th.
Grateful, your lord.
On the prayer of the respondent, the matter is adjourned till August 12, 2025.
Lordship.
Grateful, your lordships.
Thank you. Please give all the information. অনিন্দিতা যদি বাচাওয়াত বা অভিজিৎ মিত্রর নাম দেয় তাহলে ওটা বাদ দেবে রঞ্জন বাচাওয়াত অভিজিৎ মিত্র বাদ ওরা নেই
The 3 and 4 are similar appeals against my lord. Awards passed in two separate references. Mr. Shuman Datta was addressing your lordship on the setting aside application.
My lord, can I pray for a short passover, my lord? He's on the other building, my lord. He'll come right now, my lord. Just only, my lord,
yes
at least till the assignment.
Mr. Shah is still available. We'll take up the matter when he comes.
My lord, he'll come, my lord, right now, my lord. 10-15 minutes.
I-
Or you can start it.
No, I can start this lordship. What's my
Start it. How soon will he come? What is he doing? I mean, not.
some
What is
matter,
it?
my lord, some matter is ongoing, my lord. What I've heard.
What sort of a matter? That is what we are.
My lord, he said 4 orders, my lord. Code 37, my lord.
Which court?
Code 37, my lord.
Judge?
Orijit Banerjee, Justice Orijit Banerjee.
Then start. Yes.
Lordship may recall, my lord. There were contracts for, my lord, for supply of iron ore, my lord, to the respondent, my lord. So the other matter, my lord, has been argued. Well, I'll start with the second matter, my lord. Kindly takes up the second volume first. It may be 941, that is, my lord.
941 is before us.
Second one.
This is volume 1. Part 2 is a part 2.
Part 2.
We'll take up part 2.
Yes, my lord, part 2. May I just hand up a short list of dates that I have prepared for this. Now, lord, page number 3 of part 2.
Yes.
The agreement starts here, my lord. My lord, I'll start, my lord. The first paragraph, this memorandum of understanding is made at Kolkata, 13th day of August in the year 2003. Then next, my lord, may kindly see clause 4. If the rest are same, my lord, supply of pig iron, manufacturing of iron and manufacturing of pig iron, rest are same. Then clause 4, my lord, whereas OMDC has agreed to provide iron ore of 63% Fe in 10-30 millimeter size to the tune of 1 lakh ton per annum to SRBSL under the following terms and conditions, subject to availability of the same. Now, in the other matter, it was 7,000 metric ton per month. This is 1 lakh metric ton per annum, and here the specification is different. This is 1030, that was 518 millimeter. And this contract was prior to that contract, the other one. And subject to availability of the same. So 1 lakh metric ton per annum subject to availability. Then the clause 5, my lord, next page, my lord. Clause 5B.
Yes.
At present, SRBSL shall be allowed to lift the materials at the basic price of rupees 428 per metric ton, excluding of royalty, sales tax, and per trip siding charges till 13th of March 2004. Thereafter, the price shall be revised and refixed mutually, keeping in view the rise in wages and price of HSD, and the price of fixed with effect from 1st April 2004 shall be reviewed and refixed on annual basis subject to condition stated at clause C and D. Now,
The advance clause is here also, E.
yes, advance clause is also here, my lord, and
Yes.
but here, my lord, it's a bit different, my lord. Participation of tender initially was not compulsory. Only see the next clause, my lord, I'll just place it. If there is an upward revision of prices applicable to KIW, ITCOL, well, this is another contract which is the same terms, my lord, for supply of iron ore with ITCOL, my lord. It's there in the next page, I'll show it, my lord.
What is different?
Differ, my lord, it's at page 6, my lord. Kindly see the ITCOL agreement is at page 6.
Yes.
This was supply of, my lord, iron ore, my lord. So MDC used to, my lord, enter into this contract with other private parties for supply of iron ore outside of tenders, my lord.
What is that?
Well,
Read
this
that.
is one such agreement, my lord. Outside of tenders, seat call, my lord, page number 6, my lord. Means if they don't want to participate in a tender, my lord, they can supply if available and subject to the
This is to show what? That they were supplying to others.
Yes, to others also, my lord. Not only to, my lord, Jai Balaji, my lord, this is also one other contract between each call, because the reference lordship will find at page 4, my lord. C. If there is any C, page 4, clause
Yes,
C, my
yes.
lord. If there is any upward revision of price applicable to KIW it call, my lord. So that is the other contract that which I was showing just now. Similar upward revision shall be made in the price for
Why is C relevant? We don't understand.
So C is as to the price, my lord. If
Yes.
there is a revision in price for the other contract, then this revision will also apply here.
All right.
They will have to pay in the revised price.
Ask.
So price is not fixed, is upward subject to revision.
So what does it signify?
Signify, my lord, price. I'll just let me place the next clause, my lord, then it will be clear, my lord. Then D, if OMDC prefers to determine the price and other terms to tender, SRBSL should participate in the tender on acceptance of applicable.
You were reading?
D, the next clause.
Yes, yes.
In case OMDC prefers to determine the price and other terms to tender, SRBSL should participate in the tender on acceptance of applicable terms of supplied by SRBSL. So decided through tender, SRBSL shall be allowed to lift the materials. Then next, my lord, SRBSL shall make the 100% payment in advance before lifting the materials. Here, my lord, what's it say? What I'm trying to imply, say, my lord, that 1 lakh metric tons per year, it's only subject to availability and later on subject to participation in tender, my lord. The price initially, my lord, clause B, which fine, my lord, 428 rupees per metric ton. Thereafter, my lord, it will be revised accordingly with the price given to the other parties, that is the KIW it call, and subject to the price fixed in the tender. The highest bidder, my lord, who comes up, my lord. So
Yes.
now, my lord, clause 6, my lord, the period of contract, the same page.
Yes.
The tenure of the agreement shall be valid for 1 year, commencing from 1st October 2003, and may be renewed for a further period solely at the option of OMDC on terms and conditions as may be mutually agreed to. The contract MOU shall be terminated by either of parties by serving 1 month's prior notice to the effect. So it's 1 year from 1st October 2003.
This subject to participation in tender is not there in the other one.
It's also there, my lord. There it's more prominent, my lord. Here it says initially they will supply without participating in tender. Thereafter, my lord, clause D, my lord, in case OMDC prefers to determine the price and other terms through SRQ tender.
D is there something similar to D is there in the other contract?
Yes, my lord. Other contracts say that is that the SRBSL will have to participate in the tender. Thereafter, my lord, they can lift it. If something is left, then they supply. They can make the supply if after the highest bidder lifts the goods, my lord.
Right.
Now, my lord, I'll just take your lordship to the thereafter what happened, my lord. Now, my lord, in the other matter, lordship and recall, my lord, supply was made up till June. The advance payment was initially not insisted upon. Later on, my lord, payment was not received, we stopped supplying. Only in December, the parties came to an agreement that 100% payment will have to be made for supply.
Yes.
And thereafter, my lord, the respondent paid the balance outstanding payment, and so further, my lord, the undated checks were issued, which we did not consider advance payment, returned back those checks, and we did not supply the balance part because the payment was not received. Now, my lord, this was the other contract. Here, my lord, what happened, my lord, the contract expired, my lord, even prior to, my lord, the December, my lord, that's the other contract. It was in June, my lord, kindly seize, my lord. 13th of October 2003, my lord. So it expired sometime in 13th of August 2003, it expired sometime in August 2004, my lord.
13th of
October or 13th of August 2003, this contract
13th of August
August.
2003.
2003.
Yes.
The 1st October 2003.
And it expired on?
And it expired on, my lord.
It was a 1-year contract.
It was a 1-year contract from 1st October, my lord. So it expired on, my lord. The contract was entered into on 13th of August, but the contract was from 1st October 2003. So it expired on the last day of September, 30th September 2004.
Yes.
Clause 6, my lord, it's there.
Yes, clause 6 is there.
And my lord, the other contract, my lord, started from. Yes, my lord. The other contract was from 11th of March 2004 in the other matter. So this was the prior, my lord, that happened subsequently.
Yes.
Now, Lord, after this is done, in Lordship may kindly take the list of dates, my Lord. I'll just show one of the documents one after the other, my Lord. After 13th of August, my Lord. Here, my Lord, up till June supply was made. Thereafter, my Lord, on 3rd of December, that is page 8, my Lord. I'll just show one after the other. They made a representation, my Lord. On this is the 3rd of December 2003, my Lord, page 8 of the second volume. We refer to your dispatch of iron ore such and such under Indian such and such covered under RR number such and such. The materials have been received by us, and we regret to inform the following deficiency. Then, my Lord, shortage of weight, presence of approximate 40% mud. You are well aware that since our newly set up plant is in the process of establish ourselves, losses on account of the above date will be detrimental to our growth and profitability. We firmly believe that your good self will not favor such deficiency in supplies in our mutual business interest. We request you to kindly depute representative to assess the above loss. Now, my Lord, there was a claim for deficient goods in the arbitration that was rejected, my Lord, because the goods were consumed. So this was letter for complaining for deficient goods, my Lord. The second document, my Lord, I'll just. Next page, my Lord, page 9. My Lord, here, my Lord, the supply was complained about. I would thank for the courtesy exchange when the undersigned on his visit to the office on 19th of December 2004. As discussed with you, there is an acute time lag in supply of rakes by the railways, and Indians are pending for over 3 months. In view of the above, we request you for the following: that a minimum of 3 to 4 rakes for blast furnace grades will be indented every month so that the Indians remain in queue in case the railways supply rakes faster than expectation. And if all the Indians are to be cancelled, we will be ready to bear the cost for cancellation of the indent. Then also permit us for immediate movement of iron ore by road as stock in the plant was abnormally low. This is one, my Lord. Thereafter, my Lord, we accept these terms, my Lord. Kindly takes up page 10, the next page. Letter by OMDC. Thank you for your letter dated such and such addressed to our chairman cum managing director regarding supply of iron ore containing 63% Fe 1030 millimeter. In this connection, it is to inform you that we have considered your request and ready to supply the above materials by road instead of rake. Permission has to be obtained from Deputy Director of Mines, Joda, for transporting the materials from our mines. Necessary arrangement for lifting and transporting will be arranged by you at your cost. Hence, you are requested to deposit the advance payment toward cost of materials, inclusive of royalties, sales tax, and other applicable taxes, and submit valence license from Deputy Director of Mines, Joda, in consideration of the above referred points. No, my lordship may recall, my lord, there was a issue of waiver. In the other matter, it was said that we had waived the advance payment clause and we failed to supply the remaining part. Hence, loss of profits and other consequential damage was awarded against us. Here, the same logic has been applied. But kindly notice, my lord, here we had insisted for advance payment on 3rd of March. So we never waived this clause, my lord. Then, your lordship. Then, my lord, price was revised, my lord, kindly takes up page 12.
But we supplied the goods all the same without the advance payment.
Initially, it was supplied without advance payment. Thereafter, my lord, so there are not many letters, my lord, only a few letters. December, my lord, they stopped paying, my lord, and I stopped supplying.
So similar here as in the other
Similar
one.
here also, my lord. But only the term is different, that 1 lakh metric tons per annum, that was 7,000 metric tons per month.
Ajay, have you proved anything to show in either of the matters that during the period for which they have claimed loss of profit, they say that their premise is that they were entitled to this 1 lakh here and whatever there. Now, we are taking this case, this 1 lakh. So the clause says that subject to availability. But if it's available, then you have to supply.
Yes, my lord.
So did you prove anything, produce any evidence to show that it was not available to you during the relevant period? Probably that's not there.
That is not there, my lord. Not availability is not there, but in the pleadings.
But you put it on a higher notch because you say that once they claim only then, but they had claimed.
No, they did not claim, my lord. All
During the subsequent period, the loss of profit, that period they did not claim specifically.
No, specifically did not claim. And secondly, my lord, they did not pay also, my lord. Because
not pay
without
also.
payment, there was earlier outstanding. They wanted.
That's another argument. So without advance payment, they cannot. You
Let's say,
won't supply.
even if I had wait for a particular while, you know, some payment had to come.
So you say they did not make the advance payment and did not demand that supply also during the subsequent. So the question of availability does not arise at all.
Yes, my lord. And secondly, you know, they also did not participate in the tender also.
That is also there.
That is also there, my lord. I'll just take
Very
only through the correspondences, my lord, then I'll take your lordship to the award.
Yes.
Then, my lord, page 18, my lord. I'll just take your lordship. Yes, on page 12, when I was showing page 12, my lord, lordship, page 12, the price was revised.
Page 12.
Yes, my lord, page 12. The price was revised.
Price was
Revised. Then kindly, I'm reading out, my lord. Please refer to our MOU dated 13th of August 2003 regarding supply of iron ore 63% Fe. In this connection, please note that as per clause 5B of the above MOU, the basic rule was the basic price was rupees 428 per MT in the line of price applicable to KIW. In accordance to clause 5C of the said MOU, the price is to be kept in line with the price applicable to KIW. As the selling price for KIW has been revised and refixed at 5112 per metric ton, the same shall be applicable to you with effect from 1st April 2004 till further order. All the above terms condition will remain unaltered and against the above stated MOU. No, lordship may kindly recall from the contract, if the price increases for KIW, it will also increase here, my lord. Now, thereafter, I'll take your lordship to the.
Your case is that they did not pay at all. So
later on, did not pay at all. I'll show the documents.
Did they resist this revision of price?
They did not resist.
So therefore, that is not German so much. I mean, yes. So actually, it was revised.
It was revised.
So whether if they don't pay, whether it's revised or not does not matter. They don't pay, they don't pay.
Now, my lord, kindly takes up page 18, my lord. So this is very relevant, my lord.
Yes.
Page 18, my lord, they pray for renewal of the agreement.
Yes.
Kindly refer to the above memorandum of understanding in which we had agreed at the beginning for a period of contract of 1 year from 1st October 2003 with an option for renewal. We would request you to renew the contract for further 2 years as per the same terms and condition MOU.
Yes.
So here there is no complaint of short supply of us not meeting their obligation or that they suffered loss because we could not provide them the balance. They simply asked for the renewal of the contract.
But they previously had taken that point of defective supply and short,
Yes,
not
but,
short
but,
supply.
but later on they consumed the goods. This claim was rejected, my lord. They consumed the goods, so my lord, this claim did not stand, my lord. But loss of profit, my lord, and then secondly, my lord, they had to buy the goods from the other vendors at a higher price, my lord. Those should not be applicable here because they wanted for the extension of the contract without complaining for the other damages, my lord.
No, renewal of contract in terms of the previous conditions means they are agreeable to everything.
They agreed to everything, my lord. No, this was in 8th October 2004, my lord. By the time the contract had already expired, my lord. Now, since payment was not made, the entire outstanding, the balance supply was not made. Now, after this, kindly takes up, my lord, page 176 of the same volume. अरे आगे 176 है. Date wise देखो. 176. 176. Okay.
Yes.
Now, my lord, this is same letter in the other matter also. Yes, my lord, I'm reading up.
Yes.
Please refer to your letter dated 14 December 2004 and subsequent discussion at our office on 23rd December 2004 on the above subject. It is to inform that the supplies can be resumed under the following terms. Balance amount of rupees 48,17,369 is still outstanding against earlier supplies immediately and as per 100% advance to be made before the placing the Indians for future supplies. Hence, you are requested to release the above payment at your earliest to enable us to supply the materials. Now, my lord, lordship may kindly see the subject, my lord, this concerns the other contract. Because by this time that this matter, my lord, this 1030 matter, the contract had already expired. This was subsisting. So this agreement was made, 100% for further supply was made in for the other contract. The other one we already should concluded, my lord. We did not supply, my lord. Now, my lord, after this, my lord, kindly comes back to my lord, page number 19.
So why did you enter into a fresh contract during the subsistence of the previous one? The materials were different.
The different materials, my lord. This is 1030 mm, my lord. Iron,
yes, yes.
that is 530,
right.
518 mm.
The specifications are
Specifically
different.
different.
True.
Now, kindly takes up page 19, my lord.
19.
19. It comes with what it's 28th of December 2004.
Yes.
If I know they accept this, they agree to this meeting, my lord. I am thankful for you to for the kind courtesy extended shown by you to the undersigned and our advisor, Shri A.K. Mukherjee, when we visited your office on 23rd December 2004 in the afternoon. We are your customer of iron ore since long time and know that by your positive thinking and attitude, OMBC is going to improve by leaps and bounds. Your assurance regarding iron ore supply as per MOU gave us a lot of encouragement to us. So they acknowledge this 23rd of December 2004 meeting, they have acknowledged this. The revised terms, 100% payment will have to be made, thereafter supply will be done. This is acknowledged by them.
This is the reply to 24th December.
Yes, 24th December, my lord. May kindly see page 176 again.
24th December.
Page 176.
Yes, that refers to discussion of 23rd.
24th December.
Very good. So you agreed to resume supplies under those terms.
Under those terms, only for the second contract.
Huh.
This was 580.
Second contract means this FMA 941.
FMA 939, my lord.
Oh,
so done this filed in the reverse manner. FMA 941 is the prior contract, my lord.
No, well, the papers in the two contracts have been jumbled up in the paperwork,
yes.
and your lordship might remember I had said that, my lord, none of the deposition in, my lord, either of the references is available. And, my lord, many of the papers are also not available. My lord, we had approached the lower court trying to, my lord, collect copies. It appears to be, my lord, a very difficult task. So, my lord, we'll proceed on the basis of the award and what is the finding in the award.
We have recently approached one of the learned arbitrators also to find out if they have the papers. If they
Lordship kindly takes up now page number 177, my lord. Again, the last page, my lord.
We are taking up the pages, but more the pages we are taking up, we are getting more confused because it's a cross argument between two matters.
No, my lord, now both the correspondence become same, my lord. It's only before that, my lord, I'm just showing, my lord, this supply was not done because payment was not
Okay,
made.
give us a clear
Therefore-
flow chart later on.
My lord, we will give
Clear
it a
flow chart.
Let my
Where they
learned friend
march.
give
Let
me
them
a
march.
flow chart also, because I am also getting thoroughly
Give
confused.
circulate everyone a flow chart. If you can, you can distribute it as a pamphlet among the others also who are listening to this one. Everybody is getting confused, including our interns, and it will be a very difficult task to answer them at the end of it. So you will have to bear the task. So give a flow chart later on. So make your arguments. I mean, the points. Mr. Dutt had already touched the points, main points. The points of difference you have touched in this matter. That basically the same, but the tender thing is more prominently written here. Another tender has to be there. They have to participate there. That part has been
That part is there, and this is for annual supply. That is monthly supply. My lord.
monthly supply. Yes.
Thereafter, my lord, the conduct is same, my lord, payment not made, supply not made, my lord. This is there. And then the December meeting is there, 100% payment will be made, then for the supply. And now, my lord, how the payment is being made, my lord, kindly takes a page 177.
Yes.
30th of December 2004.
It's an annual payment.
No, not annual payment.
And
my lord.
supply will be
Supply will be made upon payment. They will have to place the supply, my lord. Then we'll advance payment. Then we'll make the supply. They have to first raise the demand.
No, annual supply means you supply once a year.
No, throughout the year, 1 lakh metric
And
ton.
that was monthly. The previous one was.
It was monthly, 7,000 metric ton monthly. This is the difference in the two agreements, my lord. But the main story is the same, my lord. Payment not received, supply not done. Total 1 lakh metric ton total.
No, but that contract was for a period of 1 year also in the other.
That was also 1 year, my
So
lord.
what's the difference between an annual supply and a monthly supply? Monthly.
Annual supply means total in a year, my lord, 1 lakh will have to be supplied, and this every
The figures are fixed for the year. What is the difference, Mr.
7,000 metric ton per month.
That is what we are doing. The figures are fixed to months,
Yes.
and there and here to the to.
That throughout the entire upon payment you get. It can be 5 kgs upon payment.
So that
of-
amount will have to be can be given by you throughout the year if available.
Yes. If available upon payment. It's like, Millard, if I pay for 5 kgs, I take 5 kgs if it's available. If I pay for 10 kgs,
But there over the month you have to supply that amount.
7,000 metric ton per month.
Very good.
So it doesn't, like, if this month you don't take.
The total amount is fixed for the month, and there and here the year. Very good.
Now, my lord, page 177, my lord.
177.
The balance payment is now made here, my lord. We have received your letter on the subject and pleased to enclose our check bearing number 67 such and such for rupees 45,64,633 drawn on Indian Overseas Bank in full and final settlement of our dues.
So they pay up that amount.
They pay up the balance amount, the earlier outstanding amount.
Very good.
The outstanding, not the balance. No? Thereafter, my lord.
So why are you placing this to show us that they have paid their
paid subsequently? That's also after the contract expired, my lord, the payment was made. The outstanding after the long after the contract expired.
This can be significant for two things. One is that they paid after the contract, but that is immaterial because if advance payment was necessary, need not pay after the contract. After the supply, you also will do. But another aspect is that probably in this they also don't raise any objection as to short supply or something.
No, no objection was
while
raised.
paying.
While paying,
you can argue that also.
Yes, my lord, that is also there.
May I have your
Yes,
lordship?
Mr. Kindly takes up page 20, my lord.
Finish quickly so that he
No,
can.
it's not done, near about done. My lord. The award will now be placed by.
No, finish quickly so that Mr. Saha, before Mr. Saha
Yes.
comes through. Yes.
Lord, kindly takes up page 20 now, my lord.
20. So it's like a construction of a bridge. You are progressing from the front and from the back, and we'll meet in. Where do you meet? Page 76, around 7600.
Yes.
Yes.
Page
Please
20,
continue.
20, my lord. Now we'll find, my lord. 30th of December 2004, my lord. After they make the balance payment, what they do, my lord? Dear sir, with reference to our letter such and such, with respect to supply of 1030 Fe sponge grade iron ore to our sponge iron plant at Durgapur. In this regard, we are pleased to enclose here with 3 checks bearing number such and such, each all drawn on India's Overseas Bank. You will observe from the above checks that we have left the dates blank. You requested to fill in the dates and present these checks to the bank Only after the rakes have been dispatched to us, before presenting these checks for clearing, kindly intimate us of the same to enable us to make necessary arrangement. Please note, we will not be liable for damages due to non-intimation of presentation of checks, return of checks by our bankers. So not after the contract got expired.
So you have to read this page with 177.
Yes, my lord. After the obligations are fulfilled, my lord, as to our part of supply, and they did not pay, my lord, balance. Now, my lord, in December, they're asking us to, they're sending us undated checks, not advance payment, then asking us to make the balance supply.
No, but undated checks means you can fill up the date. So this can be treated as advance.
No, my lord, it's not
The next
then
supply.
inform.
But
they have
then
to
by
inform
then
their
the contract
banker,
is
my lord.
over.
But it says, my lord, that it has to be informed to their banker, my lord. Before presenting for clearing, kindly
Oh,
intimate
that's
of the same,
subject to that.
it's not back with
Same
funds.
thing as in the other matter.
It's the same thing, my lord, same letter. Huh? And also after the rake has been dispatched.
Yes.
No, my lord, these checks were returned, my lord. That check returning letter is in the other matter, my lord. This same letter, my lord, it's not annexed here, my lord. Volume 2 of FMA 939. Yes.
Yes.
Lakshmi, now kindly take a volume 2 of FMA 939, my lord. This page should have been annexed here also, my lord. It's not here, my lord. Part 2 of FMA 939.
Part 2. But the volume 1. Part 2 is a
Page number 22.
Yes.
Fine, my lord, the checks were returned. Please refer to our letter dated, letter number such and such, dated 15th March 2005.
So what do we transition from this 941 and 939? I mean,
Same, my lord.
cross serving the same almost.
Same almost, my lord. Only the conditions of contract were same, but the conduct of the parties are perhaps not that different, my lord. And here, my lord, we'll find, my lord, the checks were returned, the initial 3
Where
checks.
do we get the papers regarding this corresponding papers of 941? Because in 941 you have annexed 939 papers.
No, my lord, only this same document, only this document is, my lord, relevant, my lord.
939 and 941 covered by the same papers.
That what had happened, my lord? Claimant is the same, respondent is the same, two contracts, two different contracts. So, my lord, what has happened is up to a particular period, my lord, while the contract was in performance, the correspondences are different. Thereafter, after a point of time when the contract came to an end, he's clubbed the two contracts and sent me checks. I send it back clubbed. So
it happened after since when? When the first contract expired or the second contract?
Millard, it's expiry of both the contracts. After the first contract, also the second contract, because both were for 1 month. For 1 year. I'm sorry.
So then, when do the common correspondence start?
What I propose to do is, Millard, is
Yes.
this. Millard, I'll make a comprehensive list of dates, including both the contracts together, if that commences to your lordship.
Yes, or if it's like a flowchart, that will be easier. We said that when they merge.
Then I'll do it.
This contract, and
these are the letters. These
and
are
then the common correspondence.
and the common documents.
Like a computer program, those flowcharts.
So, Millard, another thing, Millard, so far as this is concerned, Millard, I might draw your lordship's attention. It account at a paper book,
So your base arguments remain the same, Mr. Dutt.
Yes.
First of all, there was no waiver. Even if waiver, alternatively, even if we were restricted to those months when you did not insist upon payment.
That is in the first one.
And this
In
one
the
also,
second one also, Millard,
that
I
remains the same.
insisted on payment also. Though not
But you gave the
month-wise,
supply.
I gave the supply for the initial period for whatever he is paid as
You insisted for payment, but you supplied without the advance being paid.
initial.
Both cases initially. So even if at worst it should be restricted to those months, and your first argument is that there's no waiver, conscious relinquishment, that
cannot be
itself
yes.
does not mean a waiver.
Yes.
And secondly is that the checks were even conditional, so cannot be advance payments at all.
No.
Their permission first, and after the supply, putting on the rakes and all these things. And that baseline, it was a baseline subject to availability baseline supply, the quantum.
Yes.
So it was not that it was fixed to that you had to supply that.
No.
That was also not there. And defective product and loss of goodwill, etc. These things they did not point out at the relevant point of time.
Not necessary.
They did point out, but they paid.
Rejected. Their claim was rejected.
Claim was also rejected, right?
Claim was rejected. In fact, Millard, in the second one, Millard, or the first one, whichever you lordship, 941, Millard, the entire dispute was regarding defective. As I could understand, Millard, from what had happened is, Millard, when they took the initial supply, Millard, thereafter they were not happy with the quantity of the material. And that's the reason why they did not approach us. And it's very apparent from that all the correspondences during the tenure of the contract were on defective supply, goods mixed with mud, this, that, and all. And therefore, they had raised issues, site inspection. There are also letters to the extent that we are not in a position to take goods from you until and unless you better your quality. Now, mines is not my production. It's a natural thing, Millard, which comes out from below the earth. And that's the reason, Millard, I understand, is they did not apply for supply thereafter and kept it at that. Thereafter, Millard, when probably they thought that when the contract had expired, in the second round of in this 941, the correspondences will indicate that they realized that the contract was coming to an end. And all the correspondence subsequent there to Millard is for extension of the period. And my stand was that we have already floated a tender. You participate in the tender, be the lowest bidder or highest bidder, whatever, and take it. Now, Millard, the reason why I was drawing your lordship's attention to this paper book is, Millard, I chanced across this at page 120.
This is FMA 939. Kunta.
930.
Sorry, Mr. Dutt, which page again?
Page 119, it starts.
Yes.
Millard, affidavit of evidence of Anup Kumar Agarwal on behalf of the claimant about it. Has my lord got it, Millard?
Yes.
I'm not drawing your lordship's attention. He says that these are the documents which I have relied upon at the bottom of that page for the purpose in support of my claim.
Yes.
And all these documents are before your lordship, Millard, in the index. So, Millard, in this case, Millard, subject to correction, there won't be any other documents which are not available before the court.
The evidence was adduced
Yes. Evidence
by affidavit.
by affidavit.
This is the evidence.
This is the evidence.
There was no cross-examination or something.
There was some cross-examination.
That is not there on.
That I could not lay my hands on, but there is some expert there in the award itself. But so far as this is concerned, Millard, kindly see 30th July, if your lordship matches it with the index of documents which your lordship has, each and one of them will match. Except, Millard, there is one additional document over here, which is not over here. So, Millard, I thought, Millard, your lordship's apprehension was I'm deciding something without knowing whether the entire papers are before me. So that's the reason, Millard, I showed.
So, Mr. Shah pointed out that all the papers are not here.
He's only interested in the cross-examination part of it.
Yes.
But the evidence, documentary evidence, and I have restricted my submission only on the basis of the documentary evidence. And I said that this evidence cannot support this.
And you rely on the agreements because both sides are relying on that, obviously.
Beyond that, Millard,
The terms of the agreement itself. And also the admitted dates of the payment of the checks. And those letters are there to show that subject to our prior sanction, you have to encash.
and those letters come from the claimant.
Their custody.
So, Millard, in both the arguments, both the cases, my argument is the same, that
Yes.
based on those documents,
Hmm.
it cannot be said that I was in breach. If there is no breach, then the consequences of Millard 73 liquidated or unliquidated doesn't come. And the arbitrator has proceeded on the basis that I was in breach. For not-
Arbitrator has granted claim of loss of profit.
loss of profit and
Yes.
আরেকটা দিয়েছি। And Millard
On
the
breach.
price of difference in the price of goods,
That.
which yes, those two have been granted in both the case. In fact, Millard,
Nothing on breach of contract.
there is an observation on the breach. Breach is to the extent that since you have waived
Achha.
the payment and thereafter you have not supplied, therefore this payment term is immaterial. It was your obligation to go on supplying. You have not done it, therefore you are in breach.
So that the contract has been sort of revived by the award. Not-
Rewritten by the award. Rewritten by the award.
So, it says that you were to continue supplying.
Yes. Our case before the arbitrator was no payment, no supply. 100.
Yes.
He said that you have initially
Accused to that.
accused to that. Therefore, the entire course of the contract, irrespective of whether you ask for payment or not, your obligation was to go on supply
And that amount, minimum.
at that amount and without insisting on payment.
Advance
Advance payment.
payment, obviously. Very.
And Millard, the paragraphs of the two awards are more or less identical.
Are?
Identical.
Sorry,
Identical.
identical. Achha. No, that's a good ground nowadays.
No, I don't say that. He is what he has, with all respect, Millard, what the arbitrators have done is, Millard, they have tried to bring the points in common, breach common.
Yes.
So that's why, Millard, the finding, the substance, everything is common. The
Now we are also cautious, Mr. That in one set of matters, 5 matters were taken up by us, decided together. 2 other matters, both sides said that all points are same. So it will be an identical judgment. So we were going to copy paste, but then we remembered, and then what we did is clearly stated that we have passed a judgment, similar matter, identical matters, and this is the logic of those judgments, and following those judgments, we are passing this. We did not copy paste. I mean, now, but that should be there also, some transparency. That why you are.
Why not, Millard?
Why not exactly? I mean, if it's exactly identical, why not? And even copy pasting some portions of the arguments, if you say those are arguments, that these are the arguments of the claimant and these are the arguments of, if you put it as a logic of your order, in any event, you paraphrase often.
Millard,
If you accept your argument, Mr. Dutt, if yours is in better language, then I may have a complex and I may paraphrase. But otherwise, I should have, ideally, I should have quoted that. I mean, anyway.
Millard, I really don't see why not till such
This
time
copy
we
paste
find-
aspect is being too hyped. I mean, this is not plagiarization. I mean, this is no question of, you cannot plagiarize from yourself.
The only problem I have, Millard, with copy paste is, Millard, the recent Supreme Court judgments which run up to 150, 60 pages.
No, that's a different proposition altogether.
I know, because by the time I
That's
read
a
that-
collaborative effort.
I know. So, Millard, what happens is, Millard, we are at loss to find out that line where we used to start having considered the submissions. That line we don't find. And we used to start reading from that.
Spread all over.
It's correct. So,
You
Millard,
have done precisely what we requested you to do, to stop it a bit quickly so that Mr. Shah is at a
no,
loss.
that's award, Millard, your lordship, it's identical, Millard, your lordship
No,
can
need
take
not.
it from me. Only the essential facts are different.
Yes.
Somewhere he has made a mistake in bringing that fact over here. But I am not saying that that was intentional.
You're on the principles mostly.
I'm not on that he didn't apply his mind. I'm not going to that extent. That's
We
personal.
can
again.
fully identify with him why he did so.
No, Millard, it's human to make these errors.
So that's why you are asking for a flowchart. That is the reason.
কোনটা paragraph দেখাবো বলো?
What is that? That means
Millard, দুটো ফার্স্ট দুটো হচ্ছে ওয়েবার তো Milord Motilal Padampat Sugar Mills, the very old judge. Hey, copy them. And within Sikkim Subba Associates, Milord, these two judgments are on the question that waiver has to be expressly pleaded. Because, my lord, I had told your lordship, Milord, that this waiver was with, if at all they had, there is not a single line of waiver anywhere in the pleadings.
Conscious relinquishment of a right.
So, Milord, if they say that I was in breach because I had initially supplied and thereafter, then waiver was the ground available to him at the date when he filed the statement of claim.
Yes. Yes.
There is no pleading of waiver.
There's no pleading of waiver.
No. Milord,
Any paragraphs if you
Milord, the paragraphs I'll tell your lordship, Milord,
probably 5 and 6. As you get from the head. Probably 5 and 6.
paragraph 5 and 6 in Motilal Padampat.
Is that you get from the head notes?
Yes. In Sikkim Subba, Milord, it would be paragraphs 15 and 16.
All right.
I'll place it, Milord. I'm just
Very good.
ONGC saw pipes is for Milord that because this is a pre-amendment award. So ONGC saw pipes would govern us. Milord, kindly come to paragraph 74. That's the concluding part. Associated builders, Milord, wherever it takes a difference 14 to 40, my junior has.
Associated builders is a common.
Yes.
You rely on the entire judgment or something.
And Milord, the two current judgments, Milord, but of Unibros and
Yes.
Partly Boy regarding how to quantify the is that profit. In case of unliquidated damages, you will have to prove every part of it. It's not a profit-making clause. But Milord, here, though I've cited these judgments to argue that these things were not proved, but Milord, my crux of this is at the root of it, that if there is no breach, there cannot be any loss. Or I may not be responsible because I am not at breach.
Right.
Hey brother, তুমি start করবে না কৃষ্ণদা করবে ডাকো না
It doesn't come, so we'll continue.
This is something Milord I learned. If Milord since I learned from Milord late Mr. Dipankar Ghosh.
What?
Milord, we were addressing Milord an appeal before the division bench of Justice Rumapal. And Milord, he was the leader in one side with Mr. Kapoor. Thereafter, Milord, a battery of.
Yes.
And this side, I was led by Milord. I was 2 years in the profession then. Mr. Joynto Mitro, Mr. Pradeep Ghosh, Mr. Shomit Talukdar, Mr. So-and-so, and thereafter me. I was the last.
All of them ditched you.
All of them, Milord, after our submissions were made, Milord,
Yes.
all of them left, and I was left, and Mr. Ashish, I was.
But that is how we learned, Mr. Dar.
Yes.
Actually,
So,
so many matters. They
Mr.
ditched, so we learned.
So Mr. Talukdar was my senior, and he said, "I'm leaving. You take notes of whatever Mr. Ghosh." Now, Milord, Mr. Ghosh stood up, and within 5 minutes, he took the question of maintainability of it. And it was our appeal. So the court, Milord, your lordship, new Milord Justice Paul, looked at and said, very well, if it's a question of maintainability, then let me hear the maintainability point first on the other side. Mr. Ghosh looked at me and said to the court, I find a rank junior taking notes. His leaders are not here. Kindly permit me to address the court for some time. And he turned around to me and said, join to Pedako. And I left the papers and I ran. So that's why we learned.
No. We won't embarrass them. All of us were juniors time flies.
Yes.
So a few years back, I say.
Milord, if you're.
No, if they're in difficulty, they are competent to start, but we are not questioning their competence. But if
I'm not. I just, as I asked him.
No,
he
we
said,
understand.
Is he willing to
So that
start?
they're not embarrassed.
Yes. Milord, kindly come to the compilation, page 12.
What we do generally, Mr. Dutt, in our court is that we ask junior to insist that junior start. Otherwise,
Milord,
we won't grant them time. Absolutely.
That I know.
They start if we feel that they're, this is not for the juniors. Please shut your ears. If you feel that they lose the matter, then we adjourn the matter.
I know.
If
That
it's in
I-
their favor, then we record their senior's name and just.
that
এখানে waiver has to be pleaded.
page 5, paragraph 12 of the
Page 12, madam.
page 12, paragraph 5.
Which one?
Motilal Padampur
Motilal, first.
We shall first deal, paragraph 5, Miller.
Perfect.
We shall first deal with the question of waiver, since that can be disposed of in a few words. The High Court held that even if there was an assurance given by the respondent number 4 on behalf of the state government, and such assurance was binding on the state government on the principle the appellant had waived its right under it by accepting the concessional rates of sales tax set out in the letter of so dated. We do not think this view taken by the High Court can be sustained. In the first place, it is elementary that waiver is a question of fact and it must be properly pleaded and proved. No plea or waiver can be allowed to be raised unless it is pleaded and factual foundation for it is laid in the pleadings. Here it was the common ground that plea or waiver was not taken by the state government in the affidavit filed on behalf in reply to the writ petition, nor was it indicated even vaguely in such affidavit. It was raised for the first time at the hearing of the writ petition. It was clearly impermissible without any amendment of affidavit in reply or supplementary affidavit raising such. If waiver were properly pleaded, then Millard, those are facts of those cases. So Millard, thereafter Millard, if your lordship takes paragraph, paragraph 15 and 16 of the next judgment, which is Millard 2001 volume 5 SCC 629 Sikkim Subba Associates.
Yes.
Start from page 48. Start from page 48, Millard, paragraphs 15 and 16. Each the word. Page 65. একবার বলছি 60 তারা হ্যাঁ এটাই করবো তো Millard, at the bottom of page 65, your lordship will find waiver. Waiver involves the conscious, voluntary, and intentional relinquishment or abandonment of a known existing legal right, an advantage, benefit, claim, or privilege.
This is where?
This is Millard, page 65.
Oh, 65.
Part of the judgment of
Yes,
Sikkim.
waiver.
Yes. Paragraph 15, 16.
And here also in paragraph 15, placetum between E and F, page 63, even if it is assumed for purposes of consideration that persistent and continuous wrongs and defaults, even if it is assumed that the state have waived past lapses, they cannot be compelled to condone the persistent and continuous wrongs and defaults. So that second argument of yours. Even if we had waived, then we cannot be insisted to carry on that.
Yes.
And then we come to waiver at page 65 as your.
Millard, 65 bottom.
Yes.
Waiver involves the conscious and voluntary international relinquishment or abandonment of a known existing legal right, advantage, benefit, claim, or privilege which, except for such waiver, the party would have enjoyed. The agreement between the parties in this case is such that its fulfillment depends upon mutual performance of reciprocal obligations, constituting the consideration for one another, and the reciprocity envisaged and engraft is such that one party who fails to perform its reciprocal promise cannot assert a claim for performance of the other, and to go to the extent of claiming even damages for non-performance of the other party. He who seeks equity must do equity, and when the condonation or acceptance of belated performance was conditional upon future good conduct and adherence to the promise of the defaulter, the so-called waiver cannot be considered to be forever and complete in itself, so as to deprive the state, in this case, of its power to legitimately repudiate and refuse to perform its part on the admitted fact that the default of the appellant continue till even the passing of the award in this case. So far as the defaults and consequent entitlement or right of the state to have had the lotteries either foreclosed or stopped further, The state, in order to safeguard its own stakes and reputation, has continued operational, even undergoing the miseries arising out of the persistent default. The same cannot be availed by the appellant as used as a ground by the arbitrator to claim any immunity permanently for being pardoned, condoned, and
Same is
waived.
elaborate. The same thing is elaborate. Waiver has to be case specific. In a particular instance, I have waived, but it cannot be a right of the other side to claim waiver on every instance because
Yes.
once I have waived.
Once I have put down my foot and said, I am not
Probably the arbitrator proceeded on the basis that there was a waiver of the clause itself.
Well, he
That
did.
could only be the only logic.
Your
That the
lordship is-
clause itself was waived, but you never waived the
No,
clause.
no, no. I insisted on payment. in
Rather,
both
you
counts.
insisted.
Yes. Well,
And since Mr. Shah is there,
suffice, my lord, I know.
so we need not read all the paragraphs.
Well, lordship, you say it will be-
Yes, yes, sir.
Right, note me.
But, may I start with the first matter?
Yes, sir. They have completely coalesced in our mind as far as the facts are concerned.
No, well,
So you can give the distinctions as you go along.
well, I'll just tell your lordship one thing. Well, your lordship has been hearing, well, this whole thing about waiver.
Yes.
Well, what has the tribunal held? The tribunal has held that, my lord, by the course of conduct, you never insisted that 100% payment will have to be made. Now, my lord, that brings us straight away to section 63 of the Contract Act. Well, I'll just tell it before because
Contract Act. Yes. You can carry on, Mr.
yes, well, I'll just read this, well, because before I start off with this,
Yes.
well, I think, well, what I have to first disabuse is, well, the argument on waiver here. Well, because if your lordship sees, well, it's section 63, the language is this. I'm sorry.
You can read out, Mr. Shah. You can read out.
Yes. Every promisee may dispense with or remit, wholly or in part, the performance of the promise made to him, or may extend the time for such performance, or may accept instead of it any satisfaction which he thinks fit. Now, my lord, today, therefore, my lord, if in the course of conduct, your lordship finds that, my lord, today a certain, my lord, provision has not been insisted upon, or, my lord, in the course of conduct, my lord, they have performed the contract differently than, my lord, was originally contemplated.
Yes.
The question is, my lord, whether this would amount to remit. Now, my lord, so far as this is concerned, my lord, it is now also very clearly established. Of course, my lord, I don't have the judgment. I've just, my lord, heard my learned friend cite Motilal Padampat and Sikkim Subba on this. But, my lord, it is very clear that, my lord, today the parties may agree to an alternate course of performance of the contract, even sub silentio, by their conduct. Well, that, my lord, I should show you, lordship. But lord, I am not talking about novation. I am talking about section 63. And, my lord, apart from this,
But can that be tacit? Can that be implied?
yes, my lord. My lord, here your lordship will find that there are a number of
Sub-silentio,
yes,
right?
my lord, sub silentio, my lord, by course of their conduct. My lord, how they have conducted themselves in performance of the contract. And, my lord, whether therefore they have insisted on, my lord, adherence to a particular term, or, my lord, they have said that yes, I don't insist on.
No,
my
Mr.
lord,
Shah, we are speaking about the waiver of a particular term of the contract itself.
no, my lord, here, my lord, it is not really, I would say, my lord, here, you don't insist on the performance of the term. My lord, it can be, my lord, in my lord, a term of, my lord, phrase, it can be called a waiver. But, my lord, what, my lord, the section says, you may, my lord, dispense with the performance. My lord, that is, my lord,
Yes, but
really,
Mr. Shah, if you say that if you say dispense with the performance, it's on a different footing than giving a go by to that clause.
yes.
Now, dispense with performance, suppose I dispense with for 6 months and then I start insisting.
My lord, I completely then appreciate that, my lord, you have to then say that, look, I am waiving it for this occasion or this instance. It
But
is
there was
not
no
some-
express waiver ever. So if you are putting sub silentio principle there in action, then why shouldn't it should be on the same footing? The moment they insisted, they asked for the advance.
No, my lord, there was no, well, so far as that
During the
is
tenure
concerned,
of the contract,
when
did
they
not.
ask for, my lord, payment, the entire payment is made. That I shall also show to your lordship. There's no difficulty
But
there.
with those riders,
Yes, but, my lord, what happened is, my lord, just to, my lord, give your lordship, my lord, the narrative on which I wish to proceed. My lord, up to June, my lord, some supplies made sporadically.
yes.
What my learned friends say is that you are entitled to 7,000 metric tons per month. Now, my lord, so far as per month is concerned, there is never my lord, any representation that look, in this month I've given you 3,000, balance 4,000, I have no obligation to give. Next month I've given you 5,000, balance 2,000, and no obligation to give. My lord, what the parties understood, that my lord, it may be staggered at 7,000 metric tons per month, but that does not ultimately disentitle, my lord, the claimant from receiving the entire total quantity. Because the representation in the contract was that I need it for my manufacturing purposes, and that's why I'm entering into a long-term supply contract for you. Pause here for a moment. After June, why were the supplies not made? My lord, after June, my lord, what happened is there were serious disputes raised with regard to quality. That your lordship will find from, my lord, the documents and from the award itself. Now, my lord, we were trying to resolve these quality disputes. My lord, because, my lord, our contention was that, my lord, so far as this is concerned, if you're going to supply us this kind of quality, then we are going to suffer a loss in our production. And, my lord, it is, my lord, during this period from June to October that, my lord, these disputes were being sorted out or attempted to be sorted out. And ultimately, I made a, my lord, claim for this on this account before the tribunal. My lord, every aspect of the claims and the counterclaims have been dealt with in elaborate details by the tribunal. And my lord, my lord, must confess that I'm quite impressed. My lord, ultimately, your lordships may accept the logic of it or not. But my lord, kindly see the approach. I shall, my lord, take your lordships through that. Now, my lord, so far as this is concerned, these were the disputes that were going on. But in the course of these disputes, my lord, whether they will take back the goods, replace the goods, my lord, give us, my lord, remission of the price, etc. My lord, the question of, my lord, further demands, my lord, as such, my lord, did not arise because the demands were always there. Even in October, your lordship will find that the demand is there. Now, my lord, so far as this is concerned, ultimately, my lord, when these disputes are going on, my lord, the question of, my lord, holding on to the payments till the resolution of disputes is, my lord, one of the questions which cropped up. But well, when ultimately they say that we shall cancel the contract if you don't pay, we pay the outstanding amount for the supplies made. And, my lord, we also say that, my lord, the contract is valid till the end of March. We, my lord, give them, even according to their, I say that we gave them the checks in December. They say you gave it to us in March. But, my lord, even if I give it to them in March, that is before the expiration of the contract, there's an obligation to give me. Then, my lord, they raise the dispute that no. We are going to float a fresh tender now. We will not give you any goods. My lord, when the agreement between the parties was tender or no tender, I am entitled to receive. Tender is only a price discovery mechanism.
You have to match that.
Yes. And, my lord, there is no dispute about my having not matched it. It was a price discovery mechanism, which, my lord, discovered the price, and it's on that basis that they demanded and I paid.
But doesn't the clause say you have to participate there also?
No, my lord, here, may I take your lordship, my lord, through the relevant clauses of the tender once?
Yes.
Let please have a look at, my lord, the agreement. Agreement first. My lord, that's at page 16.
16 of 941.
16 of 939. I'm, my lord, addressing your lordship on the first matter first.
Page 16 of part 2.
My lord, that is, my lord, in part 2, yes.
Yes.
My lord, since I'm...
Yes.
Since I'm showing your lordship, my lord, the agreement, may I just show your lordship all the relevant clauses, which I think...
Yes, absolutely.
Yes. My lord, please have a look at, my lord, part 2, page 17, internal page 2 of the agreement.
Yes.
My lord, this is the representation, clause 2. Whereas SRBSL is the manufacturer of pig iron, for which basic raw material is iron ore. Hence, SRBSL has approached OMDC for entering into a long-term supply contract for fulfilling their requirement. My lord, I manifest my requirement and I say I need it on a long-term basis. Then, my lord, client see clause 4. Whereas OMDC has agreed to provide 7 metric tons of sponge iron calibrated iron ore of 65% Fe, 5 to 18 mm per month of SRBSL under the following terms and conditions, subject to availability of the same. My lord, your lordship's question was, is there any document to show that it was not available? My lord, there is no document on record. Then, my lord, for your lordship, next is paragraph 5b. SRBSL will participate in the tender called by OMDC and will try to be the highest bidder, failing which OMDC may provide 7 metric tons. Now, my lord, may I just pause here for the word may? But your lordship will find from the subsequent, my lord, clauses, it becomes shall. SRBSL will participate in the tender called by OMDC and will try to be the highest bidder, failing which OMDC may provide 7 metric tons of sponge grade calibrated iron ore of such and such per month to SRBSL. Then, my lord, kindly see, subject to acceptance of SRBSL to procure the materials at the price and other terms and conditions accepted by the highest bidder. So, my lord, I don't have to participate. Even if I do not participate, but I'm entitled to the goods at the price and terms and conditions accepted by the highest bidder.
But Mr. Shah, it says you will participate in the tender, will try to be the highest bidder, failing which. So it's on the alternative.
Yes.
But you have to participate in the first place.
Well, they have never insisted on this. Well, so their understanding of this clause is you can participate, but even if you do not, doesn't matter.
You have to match the highest price.
Yes. Because well, that is how they have proceeded. Even when I have not participated, well, they have given it to. And well, that is the finding of the tribunal also. Then will apply, please see clause C. SRBCL shall make 100% in advance, payment in advance before lifting the materials. Well, this is the clause on which my learned friends rely. SRBCL, if it becomes the highest bidder, OMDC may provide additional quantity over and above the committed quantity as indicated in 5B. Now, what this means is, even if you do not become the highest bidder, whether by participation or non-participation, well, the committed supply will be given to you. If you become the highest bidder, over and above that, you may get something more. And then, my lord, will please see the next clause. OMDC shall have the right to give the contracted material to any other party if SRBSL fails to lift the material at the highest bidder's price. Again, my lord, whether my participation is there in the tender or not, my lord, is not really relevant. OMDC shall provide 7,000 tons of sponge iron calibrated ore per month from 1st April 2004 during the tenure of the contract. And then the period of contract is mentioned. It is valid for 1 year from 1st April 2004, which means it expires on the 31st of March 2005. Well, these are the relevant terms of the contract. Now, so far as this is concerned, well, the case, my lord, made out in the statement of claim and the counter statement, I will not show you lordship independently, because my lord, the award is, my lord, very elaborate, and my lord, it deals with both sides of my lord, the case presented and the case, my lord, in defense. My lord, may I request your lordship to now take up the award? My lord, that your lordship will find at page, my lord, 64 of the first volume.
No, it is supplementary. 939 is Emni first volume, part 1. Right. $939 first volume.
My lord, please see page 63 of volume 1.
Yes.
My lord, the award starts at page 63. My lord, may I straight away take your lordship to, my lord, what is the case made out in the statement of defense? That starts at paragraph 5 at page 66. My lord, this is the case run in the counter statement. And because it's, my lord, elaborately reproduced here, I didn't want to trouble your lordship with the pleadings. The respondent had filed a counterclaim statement of claim disputing the above claims of the claimant. Well, the first defense is respondent had no obligation at all to make supply, as the agreement was purely of a temporary nature and there was no commitment on the part of the respondent, irrespective of the claimant's participation in the tender or becoming the highest bidder to provide the goods. Then no supply was made because there was no request made by the claimant for effecting any supply, and as there had been large-scale default in making payment. Then, my lord, 100% failed to make 100% advance payment in terms of, my lord, the agreement. Then the fourth point is failed to participate in the tender. Fifth point is, my lord, it was subject to availability of the goods. Sixth point is, my lord, claimant had failed to furnish sales tax declaration forms. Well, and that is, my lord, the gist of it all. Then the issues were framed. The issues are very cryptic issues. They basically talk about the claims and counterclaims. All of them become issues. Now, the first thing which the tribunal deals with, your lordship will find is that paragraph 11, the real intention of the parties to the contract. The terms of the contract are discussed. The question is the inquiry there at the fifth line of paragraph 11. Therefore, it is necessary to ascertain what was the real intention of the parties under the contract and the scope thereof, and thereupon to find out as to whether the parties had in fact fulfilled their respective obligations under the contract, and if not, what are the consequences. This is the first inquiry made by the tribunal. Then, the clauses are discussed. I will not trouble your lordship with all the clauses. Please have a look at page 71. About 6 lines from the top of the page, your lordship will find.
Yes.
Specifically mentioned that claimant being a manufacturer of pig iron, the basic raw material required is iron ore, and for fulfillment of such requirement, an approach was made for entering into a long-term supply contract. Such intention of entering into a long-term supply contract, pre-contract correspondence exchange between the parties, namely letters dated such and such. Unfortunately, all the letters are not on record. Exhibits 2 and 3, whereby and whereunder the claimant had intimated about the requirement of iron ore and thereby requested to enter into an agreement for supply of such quantities in reference to earlier agreements entered into between the parties. And then, finally, in paragraph 13, this is what the tribunal concludes. Therefore, the primary intention and object of the agreement was to provide supply of agreed quantities of sponge iron during the contractual period in order to maintain the manufacturing process continuous. Now, so far as this is concerned, this is how the tribunal interprets the agreement or intention of the parties to enter into the contract. And if one looks at the clauses, and if one applies the rule that not impossible but probable, in that case, you can't really find any perversity in this logic that is applied. Now, thereafter, if your lordship sees, next, the next question that fell for consideration is, the question of inferior supplies. Here the tribunal held against me, but why is it important? This is important to show as to why, after supplies were made during the months of March, April, May, June, there was a pause in the arrangement between the parties because there were disputes. Now, that is what I want to show to your lordship from paragraph 15 onwards. 15, your lordship will find last 3 lines or the last 4 lines. It was the claimant's case that out of the supply made by the respondent, there was supply of inferior quality of goods to the extent of 2290.20 metric tons. This supply of inferior quality was made on the 23rd of June 2004. This is when dispute with regard to quality surfaces. And then your lordship will find that letters are exchanged between the parties. I don't want to trouble your lordship with all the letters. Analysis, samples, inspection, etc., etc. This goes on. Then, please see after that, paragraph 17.
Yes.
Subsequently, by another writing dated October 8, 2004, the claimant had referred to the earlier letter of objection and intimated about the supply of poor quality of goods and further intimated that the plant is suffering for short supply. Now, why is this important? Because this shows that we were asserting our need for the goods, but the dispute that was there between the parties was with regard to inferior quality of supplies made for a very significant quantity. It's more than 2,900 metric tons. Thereafter, your lordship will please have a look at the disputes that rage between the parties again. And finally, they said because you did not supply, that's paragraph 18, claimant's case is that no supply had in fact been made by the respondent after June 2004, as stated in paragraph 22 of the statement of claim. This was admitted by DW1 in answer to question such and such. Claimant's further case is that since the respondent committed default in supplying the balance quantities under the agreement, it had to procure 47,413.70 metric tons of sponge grade calibrated iron from outside sources. Now, there are 2 claims. One is on account of the excess price paid for procuring this quantity. The balance quantity was in the region of 70,000 metric tons. And the rest is, my lord, for loss of profit because I could not get the material and could not manufacture goods. Then, my lord, we come to again, my lord, the question of inferior goods and inferior quality. My lord, this, my lord, goes on.
But can the two claims coexist, Mr. Shah? Because if you claim an amount for taking it from some others,
yes,
and utilize that for making your profits, I mean that if you had got the goods and
my lord,
then,
total, my lord, I am supposed to get 100.
Right.
My lord, I get, my lord, 30. My lord, balance is 70.
Balance, regarding balance, yes, but can there be an overlap of the two? The amount you procured from others, you are asking for an
No, my lord, here, my lord, your lordship is right. I would not ordinarily be able to do. But, my lord, what I procure from others is, my lord, 47,000 tons. What I cannot procure from the market because the goods.
Yes, regarding that's what we are saying. Regarding the quantities, those cannot overlap then. Regarding the quantity which you obtain from others,
Yes.
and you have a claim for that amount, that you utilize that amount and obtain profits on that.
Yes.
But regarding the quantum which you could not, that you may be entitled to.
So far as that is concerned, one is, my lord, I obtain at a higher price. So my claim is confined only to the higher price.
Difference of price.
Difference of price. That is the only, it's confined to that.
Yes.
The rest is, my lord, because I could not get, my lord, had I got the, my lord, materials.
For that you had to show that what was your requirement.
That, my lord, I have shown. My lord, here, my lord, my requirement is, my lord, so far as this is concerned, my lord, there's a long-term requirement planned. And, my lord, that, my lord, there's no dispute because they have not disputed that, my lord, I have requirement for the goods is not in dispute. Well, that is not an issue that arose between the parties in the arbitration. Well, I must also point that out because, well, no one said that you had no need for the goods. Why would you acquire it from the third parties? You had no need for the goods. Why would you then incur a loss of profit? Well, these questions, my lord, I find from, my lord, a careful reading of, my lord, the pleadings of the parties and, my lord, the award. I could not, my lord, read through all the correspondence and the deposition. I find that this is not a case that was run by the parties. And your lordship has seen that the tribunal has, my lord, identified what are the defenses. 1, 2, 3, 4, 5. And well, at the end of the day, they say that we didn't have an obligation to supply to you if you did not participate in the tender. We would also supply to you only if there were goods available. And finally, they say that so far as this is concerned, you had to pay advance price. You did not pay the advance price, so obligations.
Yes.
Essentially, that is the defense. Well, not that, my lord, you did not have the requirement of the goods. Or ultimately, my lord, you could not have suffered a loss of profit. You could not have suffered a loss on account of the goods procured, my lord, whatever goods you could procure from the market at an excess price or at an escalated price. Now, my lord, so far as the question of, my lord, here, my lord, your lordship will find, my lord, from the, I think it's a part of the award. Yes, from the award, my lord, one very important thing. Well, please come to page 76. I want to just, my lord, make this point while discussing paragraph 24 of the award.
Yes. Yes.
My lord, while deliberating on, my lord, the aspect of inferior quality of goods, my lord, this is what, my lord, the tribunal also notices. My lord, the paragraph starts at page 75. But, my lord, I'll request your lordship to kindly have a look at page 76.
76, yes.
Tapon Kumar Ghosh, DW1.
Yes.
Said bills are annexures to the affidavit on evidence forwarded by the claimant by its letters being such and such. Dated, now, my lord, kindly note the date of the bills. 26th or 28th July 2004 and bill number such and such, 26th, 28th July 2004. Now, my lord, here, my lord, this is in respect of supplies made up to June. They are raising their bills on me in July. Now, my lord, advance payment, your lordship has been told. Now, my lord, they raised their bills on me in July, my lord, for the purpose of these supplies. And, my lord, what is the narrative here? It therefore appears that bills were raised after the complaint made by the claimant about poor quality on 29 June 2004. It also appears that the defect I don't think, my lord, this is the correct expression, defectiveness of the goods were detected much prior to raising of the bills and sending sample reports to the respondent. But what is important here is, my lord, that the bills are being raised after, my lord, the disputes arise. And, my lord, the bills are being raised, my lord, with a demand for payment of these bills. Now, ultimately, my lord, the tribunal deals Your lordship.
Oh.
Well, we'll wait.
She'll be coming.
Yes.
Sorry, Mr. Shah, we are a bit late. There was something came up. I mean,
Perfectly all right.
please continue.
I showed you lordship that my lord, they were raising bills, my lord, in July.
Yes.
My lord, the effect of that, of course, my lord, the learned arbitrators have taken on record. Now, my lord, coming to the question of waiver, 100% payment in advance.
Yes.
Now, my lord, please see page 78. On the point of waiver, learned counsel for the respondent cited the following judgments. It was also pointed out by the learned counsel for the respondent that correspondence exchanged between the parties subsequent to the payment made by the claimant on 30th December 2004. Nothing was stated either about defective goods or about claim in respect thereof. According to the learned counsel, it would also not appear from the record or contemporaneous document that the claimant had said anything about its sufferance of any damage because of the alleged supply of defective goods. In this connection, my lord, evidence is taken note of. Then, my lord, Mr. Sen also cited, my lord, above judgments in support of his contention. Now, my lord, after that, please see, my lord, there is, my lord, discussion with regard to, my lord, the substandard supply of goods. My lord, I'll not trouble your lordship with that. Arbitrators have held against us, and my lord, we have accepted that finding. Page 81.
Yes.
My lord, there's a distinction drawn before the tribunal between waiver and estoppel. And my lord, this goes on. I don't want to trouble your lordships unnecessarily with it, but please see. Then, my lord, there's some discussion about this. And my lord, then we go on again to the question of substandard goods. My lord, the question of waiver is not yet decided. It will be decided conclusively later. My lord, the submissions of the parties are taken note of. And then, my lord, on the aspect of substandard goods, my lord, the tribunal goes on to discuss elaborately as to, my lord, whether the claimant is entitled to a claim on this account. That, my lord, goes on from paragraph 33 onwards. And, my lord, ultimately concludes at page 89. My lord, may I just show your lordship? My lord, paragraph 43 starts at page 88. In the instant case, the buyer could have rejected the supplies but did not do so. Admittedly, the goods were accepted because there was acute urgency. In the instant case, the claimant had made full payment of the said consignment unconditionally, and as such definitely amounted to waiver of any right by the claimant to claim any damage or for diminution or extinction of price or for return consideration. Well, what the tribunal holds.
There was a common award or two separate awards?
Separate awards.
But exactly similar?
No. Well, there is difference.
Well, yes.
Now, my lord, what is important is, my lord, ultimately says that the payment is now made on 30th December. And when you make the payment, you don't hold back any amount on account of, my lord,
yes,
on account of substandard quality. So this claim cannot be accepted.
Right.
And what is finally held, my lord, at page 89, the fourth line from the top, my lord, reference is made to sections 12 and 13 of the Sale of Goods Act. And then the tribunal holds, by virtue of the aforesaid act and conduct, the claimant had in fact waived its right, if any, on account of claim in respect of alleged defective goods. While rejecting the contention of Mr. Shah, we hold that the claimant had unconditionally accepted the said goods, admittedly by using the same, and therefore cannot maintain, should be, the claim as is made for the sum of 27 crores. Now, my lord, this is, my lord, so this ultimately answers to the law of appropriation of the goods to the contract. So, my lord, that is what the tribunal held against me. Then, my lord, so far as, my lord, substandard goods is concerned, we now, my lord, go on to the. So, my lord, your lordship has first seen, my lord, the determination of what is the basic purpose of the contract or intendment of the parties. Then, my lord, with regard to the claim of substandard goods. Then, my lord, with regard to failure to supply. Now, my lord, that your lordship will now find, my lord, this is dealt with by the tribunal from paragraph 46 onwards. Lord, may I read these few paragraphs?
Yes, please.
In the instant case, admittedly from the date of contract up to June 2004, the respondent altogether supplied 13,557.20 metric tons of the goods from time to time at 1915 per metric ton. Respondent also admittedly did not supply the balance agreed quantities of the goods to the extent of 70,442.83 metric tons. According to the claimant, even out of the total supply made by the respondent up to June 2004, there was a complaint of inferior quality of 2290.20 metric tons, for which the claim had been made, already dealt with. My lord, that claim is rejected. Now, my lord, paragraph 47. The non-supply of the balance quantities of the said goods has been stated in paragraph 18 of the statement of claim. It was the claimant's case that, as per usual practice, the claimant sent undated checks towards the price of goods with a request to the respondent to present the same after being filled up after issuance of the delivery orders. According to the claimant, the respondent did not supply any further goods out of the total balance quantities, notwithstanding several reminders and specific promise made by or on behalf of the respondent in a meeting held between the parties in December 2004. Well, just pausing here for a moment. Well, ultimately, Lordship has seen that the bills are being raised even in July. Well, in October, we are saying that we are in urgent need of goods. Well, in December, ultimately, payment is made for all the outstanding amounts, notwithstanding quality disputes that are raised. The fact of remainder and the meeting has been stated by the claimant in paragraphs 20, 21, and 22 of the statement of claim. Respondent, on the other hand, admitted that supplies had been made up to June 2004 at 1915 per metric ton. But while dealing with paragraph 18 of the statement of claim, stated in paragraph 8 of the counter statement that after June 2004, no request was made for effecting any supply, and there was huge default by the claimant towards the price of the goods, and accordingly no question arose for supplying the balance goods. So 2 points. Well, you did not demand, and well, secondly is that, my lord, you did not make payment of the price of the goods. The respondent also denied in paragraph 9 of its counter statement of having any meeting held in December 2004 between the parties with regard to supply of the balance quantities during the period between January and March 2005. Now, my lord, up to March 2005, the contract was in existence. So, my lord, in any case, meeting held or not held, obligation would continue. The respondent, however, in its counter statement did not dispute the usual practice of sending undated checks and the fact of sending a check of rupees 25 lakhs to the respondent as stated by the claimant in paragraph 19 of the statement of claim. But that is not what the tribunal goes on. It is to be mentioned that out of the non-supply of balance quantity of goods, that is 70,432.80 metric tons, claimant had procured 47,413.70 metric tons from the market at a higher price. Then we are skipping over a few lines. For the rest of non-supplied goods, the claimant made a claim for damages, as according to the claimant, it suffered a loss of profit. Then please come to paragraph 50. Therefore, these are the considerations. Therefore, in order to adjudicate the above claim, it is to be ascertained as to whether the respondent was in fault or committed any breach in supplying the balance quantity of goods. So, these considerations are all taken into account, and then the tribunal is assessing this claim. Apart from the grounds taken by the respondent as stated above, it is stated that no request had been made for supply by the claimant, and there was default in payment of the part of the prices of the goods by the claimant. According to the respondent, clearance of such payment was made on 30th December 2004, and therefore there was no supply after June 2004. This is their case. But my lord, just pausing here for a moment, your lordship now sees that there were disputes with regard to quality in the meantime. It is also the case of the respondent that the claimant did not participate in the tender and thereby did not become the highest tenderer. Further supply according to the respondent was therefore dependent on participation in the tender and becoming highest bidder. It was also the case of the respondent that the respondent was under no obligation to supply the balance quantities. Reference is made to paragraphs 10 and 11 of the counter statement. In support of the respective contentions of the parties with regard to breach of terms of the contract, several documents have been disclosed which have been marked as exhibits in the present proceeding. Parties have also led oral evidence through their witnesses whose names have been mentioned, etc. Then paragraph 53. The grounds according to the respondent for non-supply of the balance quantity of goods can be summarized below. This is their justification for not making supplies. A, there was no obligation at all to make supply in the first place. B, no supply was made inasmuch as 100% advance payment was not made by the claimant. C, no supply was made since the old outstanding dues had not been cleared. D, no supply was made as the claimant had failed to participate in the tender. E, no supply was made as there was no material left to supply. Apart from the above points, it was also the contention of the respondent that the claimant had also failed and neglected to supply the sales tax declaration forms in respect of the supplies made by the respondent, and thereby the claimant had also committed breach of the contract. It was submitted by the learned counsel on behalf of the respondent that since there was default in payment till December 30, 2004, no supply was made by the respondent. Over and above, the supply was in any event dependent on payment of 100% advance in terms of the agreement, and in absence of such advance payment, according to the respondent, it was not responsible to supply any further quantities to the claimant. If we consider this point first as to whether 100% advance payment was really a condition precedent for supply of the goods, we have to go back to the period between March 2004 when the agreement was made and the month of June 2004 when the last supply was made by the respondent. In response to the submission of the respondent about the 100% advance payment, it was contended by counsel appearing for the claimant that as a matter of fact, the respondent had never given any importance to this particular term of the contract and had relaxed the same by supplying the materials up to the month of June 2004 without 100% advance payment being demanded of or made by the claimant. According to the claimant, the clause of 100% advance payment as contained in the agreement in question had been waived by the respondent, and accordingly the respondent cannot take shelter of the 100% advance payment clause to get rid of the commitment or obligation to supply the contracted quantities of goods. If we now assess the factual position during the period between the date of agreement and up to June 2004, we find that the respondent had supplied the goods in April, May and June 2004 of different quantities at an agreed price of 1915 per metric ton, which were lifted by the claimant. It further appears that neither the claimant had made any 100% advance payment toward the price of the said goods to the respondent, nor the respondent had insisted on payment of the same prior to actual delivery of the same. It is also a matter of record that towards the price of the goods supplied by the respondent during this period, that is April to June 2004, claimant had made part and or ad hoc payment by checks which were received and or encashed by the respondent without raising any objection. From the aforesaid, it can be inferred that the respondent was in fact not serious about enforcing or insisting on the 100% advance payment clause as contained in the agreement as a condition precedent for supply of the said goods. Had it been so, the respondent would not have supplied the goods without receiving advance payment for the same. In support of the contention of the claimant to the effect that 100% advance payment as contained in the contract was waived and are not insisted upon by the respondent in course of execution of the contract, evidence was given. Your Lordship will please see at the end of paragraph 59 in this page. Ultimately, two witnesses were examined on behalf of the respondent. Mr. Anup Agarwal, etc., specifically mentioned that 100% payment clause was mutually waived and supplies were made under the normal terms. Similarly, Ajay Tantia, in his answer to cross-examination, stated 100% advance payment clause as contained in the agreement was waived by the respondent. Same would also be evident from the course of conduct of the parties. Then, paragraph 60, respondent-led oral evidence. Late spelling is wrong here. Oral evidence through its witness Tapan Kumar Ghosh, who in his answer to questions 15 to 21 in cross-examination stated that goods were supplied during April to June 2004 by 8 rigs. Exhibit 8 is the document which speaks in support of such statement of the said witness. In answer to question 22 of the cross-examination, the said witness Tapan Kumar Ghosh also confirmed that bills were raised on each rig basis. Further, in answer to questions 25 to 27, the said witness of the respondent stated that instead of 100% advance payment, the ad hoc payment was made by the claimant and received by the respondent, and subsequently the entire dues were cleared. The said witness of the respondent in answer to question 29 in cross-examination had also confirmed that for supplies which were made between April and June 2004, no demand was made with regard to 100% advance payment, and first of such letter was written only on December 24, 2004. Well, this is very important. The witness of the respondent further in answer to questions 53, 56, 58 and 62 in cross-examination had further confirmed that 100% advance payment was not insisted to and supplies were made without such 100% advance payment, and the claimant had made the ad hoc payment which was received by the respondent. In answer to question 85 in cross-examination, the said witness of the respondent had specifically confirmed that each of the supplies which was made by the respondent to the claimant was without receiving 100% advance payment, and as such decision was taken by the competent authority of the respondent. Further, in answer to questions 64 and 65 in cross-examination, the said witness Tapan Kumar Ghosh of the respondent further stated that on every occasion, claimant had deposited ad hoc payment after loading of materials, and the claimant used to make payment in such form and the respondent used to supply the materials accordingly. In answer to the tribunal's question, being question number 68, the said witness of the respondent had also confirmed that the respondent had maintained a running and continuous account in respect of the supplies of the materials under the contract. This is very important. So, the basis was the running and continuous account. Therefore, from the evidence available in record and from the oral evidence of the witnesses of the respective parties, it is apparent that although a clause for 100% advance payment was incorporated in the agreement, as a matter of fact, the parties had not followed the said term and rather waived the same by not specifically enforcing such 100% advance payment clause. If the said 100% advance payment was a condition precedent, the respondent could not and ought not to have supplied 8 rakes of goods in the span of 3 months, that is from April to June 2004, without 100% advance payment for the same. Rather, the respondent had not only allowed the claimant to take delivery of the goods without payment of 100% advance payment, but also unconditionally accepted part payment and or ad hoc payment towards the price of the goods supplied. It is also significant to note that until December 24, 2004, there was no whisper on the part of the respondent with regard to 100% advance payment for future supply, although records show that the claimant continuously made demand for supply of goods. We shall refer to these demand letters at a subsequent stage. Waiver of 100% advance payment also appears from the conduct of the respondent, inasmuch as the respondent allowed the claimant to take delivery of 8 rakes without any demand and without receipt of 100% advance payment. Had it been only one supply through one rake without 100% advance payment, then it could have been presumed.
Mr. That took a point that these demand letters were not part of the. These were never referred to. There were no demand letters from you.
No, my lord. So far as demand letters are concerned, my lord, I have made demands from time to time, and my lord, in any case, my lord, it is important that my lord today, my lord, I am not saying that made any claim for delay in supply. Well, ultimately, there are no supplies. Well, let us take whatever is there immediately available on record. Between June 2004 to October 2004,
they had supply.
There were disputes between the parties. October 2004, I write to them saying that my plant is suffering for want of goods. Ultimately, December 2004, they say that you must make 100% payment. I make payment, and that is why the arbitral tribunal rejects my claim, saying that you have appropriated the goods to the contract and made payment for the price of the goods without making a deduction on account of breach of warranty or on account of diminution in the price of goods.
Yes.
And that claim is rejected. And then from December 2004, when the question of supplies comes in and they say that make payment, then I make payment of the value of 3 crores of rupees, against which no supplies are made, the checks are returned. So, even if one proceeds on the premise.
But from June to December, there were no supplies made.
No supplies made. No supplies made after June at all.
Yes.
Up to June, supplies made without insisting on 100% payment.
Yes.
After June, we did not make any written demand as such. But from the course of conduct, we are making demands but saying that look, there's defect in quality, address that. Ultimately, when they insist that please go ahead and make payment, when we say that please give us goods, they say make payment of the balance. And so far as that is concerned, at that point of time, do we not only make payment of the balance, but thereafter also hand over advance payments for the price of the rest of the goods, which they do not supply. They return the checks. Now, your lordship will please have a look at page 44 of part 2 once in this regard. It is not as if, my lord, no demands were made at all for supply. We were continuously corresponding with regard to, my lord, the question of, my lord, defect in the quality or substandard goods. And, my lord, here your lordship find, we call upon them to supply. So, my lord, if your lordship looks at, my lord, the turn of events, up to June, supply without insisting on 100% payments.
3 phases basically. Up to June, supplies without advance they considered. And June 24 to December 24, no supply, but you raise the defect angle also.
Defect standing and, my lord, also demand for
And they
supplies.
don't demand any advance also.
No.
They don't say that due to non-payment of advance, I'm
In
not
December, they say that pay me.
advance.
And, my no.
And immediately you pay.
December, I said, clear the outstandings. And, my lord, I clear the outstandings without, my lord, any recourse to, my lord, my claims on account of substandard quality of goods. And then, my lord, I give them checks, my lord, for the balance quantity of the goods, which they return before the expiration of the contract. My lord, that is, my lord, what it is. And, my lord, here, if your lordship sees now, my lord, ultimately, this is what the tribunal holds, that, my lord, you have repeatedly raised bills. Now, my lord, pausing here for a moment. My lord, the tribunal also, my lord, deliberates on the fact that it is not in respect of one supply of one rig. Had that been the case, one may have said that you have waived for an isolated rig or for a single, my lord, consignment. But that is not the case. It became a standard practice spread over 3 months. You made supplies without demanding, my lord, for the full payment in advance against ad hoc price payments. And, my lord, so far as that is concerned, you even raised bills, my lord, ex post facto. My lord, that is what transpires. So, my lord, the question of waiver, my lord, is, my lord, the question that has to be addressed from this perspective, and that is exactly what the tribunal has proceeded to do.
And you see it is one of the plausible views.
Yes.
You started with that.
Yes. My lord, not only plausible view, my lord, this is also, my lord, supported by, my lord, what would emanate from the conduct of the parties from section 63. My lord, I am not handy with the cases.
63, yes.
But, my lord, that is, my lord, I would respectfully submit is well settled. I can, my lord, show your lordship the judgments. My lord, because if in the course of conduct of the parties waive a requirement, then, my lord, it is waived. And then, my lord, when they insist on payment, I make the payment in advance, but no goods are supplied.
No, they claim the outstanding dues in December 24.
Yes.
And claim advance also.
Yes, my lord. And, my lord, when they said claim outstanding dues in December, obviously, my lord, because they say that I will not supply you further goods unless you pay.
Without advance, yes.
And, my lord, first time, my lord, make that payment. Then I also give them, my lord, checks worth, my lord, 3 crores of rupees.
So there was a payment on account of outstanding plus that advance those checks.
Yes, 3 crores.
Which Mr. Dutt is also assailing on the ground that those were subject to your prior consent and.
One thing is very clear. My lord, we need not go to.
And after supply, after the goods were put on the rigs.
No, my lord. So far as that is concerned, my lord, they did not make any supplies after June. We make payment of all balance, my lord, dues in December.
That you have done. But
and then
the advance, you say that.
And then the advance payment, they say you made the advance payment on the 15th of March. The contract was valid till the end of March. And they returned the, my lord, checks. That is their case. And, well, that is also discussed by the tribunal. But, my lord, kindly see, only for one of the difficulties of, my lord, the modern age. And I forgot to charge my iPad. So I find it is running out of charge. So, my lord, I had to.
No, we should think about putting charger points in our courtrooms also.
Yes, my lord. But, my lord, I have a backup, my lord. I am now wiser. Because, my lord, I have faced terrible difficulties in this regard in
That's
the past.
because you use it so much.
Yes, my lord. That is also true. But, my lord, now I find it is an invaluable tool. And, my lord, when now we, my lord, go out station.
Yes.
And, my lord, we have to, my lord, join some matters which are urgent virtually.
Absolutely.
You don't have to carry any brief. Your entire, my lord, all your briefs are here.
True.
This has really become, my lord.
And whatever new statutes cited suddenly, which you did not anticipate or something like that, you can just access.
And, my lord, what is very important is, my lord, one can, my lord, open a brief and in that brief import a statute into the brief. Online. So, my lord, you don't have to go hunting for the statute, go online, search for it. It is there immediately.
There's a reference point. I mean, whenever it's required, it's there. You can have a link to that.
Yes, immediately. Now, my lord, this is, my lord, what transpired. And my lord, this is how the point of my lord is addressed, that is with regard to my lord the no request made after June 2004, my lord, that I have showed your lordship. Then, my lord, your lordship will see the next question which is addressed by the tribunal, because my lord, the tribunal had broken it up into my lord, the different grounds on which they say justify
Yes.
non-supply.
Yes.
My lord, 100% advance your lordship has seen, my lord, this is how it is dealt with.
Ends at
Now, my lord,
para 66.
yes. Now, my lord, payment on account of supplies, my lord, paragraph 64. Well, this is the second limb of the argument which the tribunal is now dealing with.
Yes.
Another significant point with regard to alleged non-payment of 100% advance is that in spite of payment of a total sum of 3 crores by the claimant on 28 December 2004 and 5th January 2005, the respondent did not supply goods covered under the said total sum of rupees 3 crores. In this connection, the tribunal asked the learned counsel for the respondent to clarify with regard to the contents of the letter of 29th March 2005 and non-delivery of goods against check of rupees 3 crores. Well, this is the advance payment. Mr. Sen, in his argument recorded in 54th meeting, fairly admitted that this letter of 29th March 2005 at page 91 of the brief of document does not refer about 100% advance payment as a ground for non-supply. It has been further fairly admitted by learned counsel of the respondent in the said meeting that the claimant was entitled to receive supply of materials against payment of rupees 3 crores made by check, which was returned on 29th March 2005, before the contract expired. In this connection, answer to question numbers 45 to 50 of Tapun Kumar Ghosh, the witness of the respondent, are relevant. Learned counsel on behalf of the respondent in course of his submission made on 54th sitting also admitted that no supply was made against payment made by the claimant, that is the said sum of rupees 3 crores. The said check for rupees 3 crores, which was given by the claimant against future supply, was returned to the claimant by the respondent's letter dated 29th March 2005 at page 91 of the brief of documents.
So March 29, 2005 letter is on the other contract?
No. This contract came to an end on 31st March. They returned the checks on the 29th of March. Other contract is it has a separate flavor also. I shall have to deal with that independently. I am already thoroughly confused about the documents juxtaposing themselves in the different
Exactly.
matters. So that is why I am confining myself to the award. Now, the admission is that no supply was made against this 3 crores and it was returned under the respondent's letter, the cover of the respondent's letter of 29th March 2005. This letter has also been referred to the respondent's earlier. This letter had also referred to the respondent's earlier letter dated 15th March 2005 at page 90 of the brief of documents. Therefore, even in the letter dated 29th March 2005, the respondent did not mention about 100% advance payment aspect and only referred to non-participation in the tender by the claimants. So, there is a flip-flop happening between the grounds on
different grounds in different letters.
Yes. Therefore, even if we assume that 100% advance payment was a condition precedent for supply, the next alternative argument is being now looked at. Therefore, even if we assume that the 100% advance payment was a condition precedent for supply, nevertheless, it appears that the respondent, even after receiving advance payment of 3 crores, did not supply the said goods. Therefore, undoubtedly, a breach was committed by the respondent towards the claimant by not supplying the said goods. Although the check was returned on 29th March 2005, that is 2 days before the expiry of the contract, no explanation has been given by the respondent as to why supply was not made against the said amount of money already paid in advance by the claimant. Therefore, the respondent in any event ought to have supplied quantities of goods worth 3 crores which the claimant could have utilized for its manufacturing process. Not having done so, obviously the respondent had not fulfilled its obligation under the contract and thereby has committed a breach. This is with regard to payment on account of supplies.
So the logic is apparently they never insisted on this advance, although they did not supply goods from June to December.
Yes,
But even then, they never said that advance, non-payment of advance is a ground.
that's
Before
right.
December, when they raised the ground, they immediately gave those checks.
I gave the checks and my lord also made payment of advance, my lord, for my lord, further goods, 33 crores of rupees.
Yes. No, checks means we are meaning the advance. Outstanding you have paid.
Yes,
Whenever they claimed advance, you paid the advance.
yes,
So therefore, there could not be any fault on your part, default on your part in not paying the advance.
yes,
The moment they insisted, you paid.
that's right. Now, my lord, and actually, my lord, the difficulty started because of my lord, the substandard goods that we claimed,
Substandard good that has been
which
consistently. That's right.
unfortunately we had to consume because of my lord, the pressure of my lord, the goods, be that as it may. Now, my lord, then the next ground is deliberated upon. Please see paragraph 67 offered onwards. This is for on the ground of non-participation in tender.
Yes.
The next ground for non-supply of the goods by the respondent to the claimant is that the claimant had not participated in the tender and supply was subject to availability of the same. In this connection, the relevant clause in the agreement should be looked into. Relevant clause in the agreement dated 11th March 2004 is clause 5B, which is quoted below. Well, the clause is reproduced. Your lordships have seen the clause. Then 66. The contention of the respondent in this connection is, since the claimant did not participate in the tender, the respondent was not obliged to supply the goods under the contract to the claimant. It was submitted by the respondent that if the claimant would have become the highest bidder in the tender, then the respondent would have supplied the same. At the same breath, it was submitted by the respondent that such supply was subject to availability of goods, and there was no unfettered right of the claimant to claim supply of 7,000 metric tons of goods. In this connection, the respondent had relied on the aforementioned letter of the respondent dated 15th March 2008 of the brief of documents and submitted that it is mentioned in the letter that since the claimant did not participate in the tender, there is no surplus quantity available after fulfilling the committed quantities to the highest bidder. Counsel for appearing on behalf of the claimant, however, submitted that the obligation of the respondent to supply goods of 7,000 metric tons per month under the contract was not dependent on participation in the tender as submitted by the respondent. According to the learned counsel for the claimant, the provision of the tender as contained in the agreement was merely intended to be a price fixation device, and supply had to be made by the respondent irrespective of non-participation in the tender. It is further submitted by the counsel for the claimant referring to the letter dated 14th October, which my lord we have just showed your lordship, that the claimant had confirmed to pay the present rate of goods which to be supplied by the respondent under the contract. It submitted that the whole object of confirming to pay the present rate was to intimate that the claimant is agreeable to pay the highest price that may be determined in a tender that may be floated by the respondent. According to the counsel, there was no other occasion for confirming to pay price at the prevailing market rate otherwise. Mr. Shah submitted that in any event, the supply which was made by the respondent during April and June 2004 was not against the participation in tender by the claimant. Irrespective of participation in the tender, the respondent has supplied the goods. Therefore, according to the claimant, that the clause as contained in the contract as quoted above was not a condition for having supply of the goods under the contract. Provision of tender as mentioned in the contract was that only for the purpose of fixation of rate which may be determined during the tenure of the agreement for supply of agreed quantities. Regarding non-participation in tender, evidence of Mr. Topon Ghosh, the respondent's witness in paragraphs 5, 6, 10 and 12 of his affidavit evidence may be referred to. Witness of the respondent in answer to questions 74 to 79 in cross-examination has specifically stated that the supply was made to the claimant without participation in tender. Therefore, in view of the above position, it was not proper on the part of the respondent to refuse supply of future quantities under the contract on the ground of non-participation of tender. It is also a matter of fact that immediately on the next date of the agreement, that is 12th March 2004, the respondent had floated tender for supply of the same goods. Well, this is 2004, as soon as this tender was, the agreement was entered into. Matter of fact that immediately on the next date of the agreement, that is 12th March 2004, the respondent had floated tender for supply of the same goods, and admittedly, the claimant did not participate in the said tender. Nevertheless, the respondent had supplied the goods under the contract up to June 2004 without raising any objection. Respondent had also not raised any question by any writing or otherwise for non-participation of the claimant in the said tender or any tender if any floated thereafter, but supply was made from time to time up to June 2004. Therefore, the plea of non-participation in the tender taken by the respondent as a plea for non-supply of the goods cannot be accepted, and hence this plea is rejected. So, my lord, this is the third objection that is raised, and this is how the third objection is dealt with. Then, my lord, we come to the question of, my lord, guaranteed, my lord, come to the question of no demand. My lord, that your lordship will find from page 82, para 82, I'm sorry.
Yes.
Well, this is the next plea, and this is how the tribunal proceeds to deal with this. Another plea was taken by the respondent as a ground for non-delivery of the goods that no demand was made by the claimant for supply of the same. Respondent's witness Tapan Kumar Ghosh, although had nothing stated in his affidavit of evidence to that effect, but in his answer to cross-examination has stated so. In this connection, questions 31 to 36 of Tapan Kumar Ghosh's cross-examination can be referred to. While dealing with the above point of no demand, we have to consider the following. Whether the contract contains any provision for advance demand for supply, whether any demand was at all made or not. What would be the consequence in law if none of the above 2 points are available? So, these are the requisites which are being looked at. The contract admittedly does not contain any provision with regard to making prior demand for supply of the goods. It is significant to note that the supply admittedly made by the respondent between April to June 2004 were without any written demand made by the claimant. Had there been such provision or arrangement between the parties, the respondent could not have supplied those goods during the span of 3 months of time without any such demand. Secondly, in any event, demands were consistently made by the claimant for supply of the goods from June 2004 that would appear from the claimant's letter of 14th October 2004 at page 78, which I've just showed to your lordships.
These are not on record.
No, that, my lord, I've just showed, my lord, page 78.
14th October and 19th November?
Yes, my lord. I'll just 14th October is on record.
Page 44 of part 2.
My lord, part 2, page 44. Well, there they say, well, we are accepting the higher price. Well,
that one.
Yes, that one. Well, and that, well, it's, there's, well, this is the
19th November is not there.
You are requested to raise your indent so that we can get material.
18th October is there, 19th November is not there.
No, my lord, that is not there because, my lord.
But one is there.
Yes. But, my lord, one would presume that this letter is there because, my lord, unfortunately, the records are not available.
No, it's specifically referred to.
Yes.
Records could not be obtained from the arbitrator.
My lord, we have, my lord, written to the arbitrator. My lord,
both of you probably have written.
My lord, we are hoping that, my lord, we'll be able to retrieve some, but we tried, my lord, very hard before the court below. Lower court records, my lord, we could not find it.
Lower court records from the section 34 court records are not available?
No, man.
Oh.
Well, in fact, my lord, I had mentioned this to your lordship that we are making an attempt, but, my lord,
yes,
I did not want to hold your lordship's quota because your lordship has, my matter is part heard.
Still not available. I mean, it's there. I mean, you must have inquired. Your advocate there must have inquired.
Available in the court records, therefore we approach the learned arbitrator now to get it.
Well, it was not available, my lord, in the court records. Which court was this? Barasat court. Court records, my lord, we have now approached the arbitrators, my lord, if, my lord, they can find out from their old records.
We should have taken this up previously and given a direction on the court to send the records.
My lord, my lord, had mentioned, my lord, that the lower court records may be called for, but, my lord, your lordships were of the opinion that, my lord, that will hold up the hearing, and I completely appreciate that.
That's
I completely
substantially the documents are on record. Then no, we didn't know that part of the records were missing. I mean, the documents, because most of them have been annexed.
But, my lord, with the greatest respect, I must submit that, my lord, no point has been taken, my lord, in the 34 application that, my lord, the arbitrator has referred to, my lord, documents which are not in existence. That would be, my lord.
Son of only one document, probably one or two here and there may not.
One or two here.
Shared the thing.
It is one or two here and there, but what is not there at all is the deposition.
Is there?
Deposition, cross-examination of the witnesses.
Yes.
That is not there at all. But, my lord, I appreciate that your lordship.
Breaker case. Has that been referred to here?
Yes, all the question numbers are referred to.
Oh, yes, those questions. That is not there at all.
No.
You have to rely on the award.
Yes. Huh?
There is no dispute regarding that.
That take it. That is not the question.
If no points were taken before the Section 34 code, nor has the Section 34 code said that those are the tribunal went wrong on those are not on record, then probably we have to presume that those were there.
Yes. And
Whatever has
with the
been quoted.
greatest respect, I did not trouble your lordship with that because I find that it is not the contention of the petitioners or the appellants before your lordship that wrong reference has been made to wrong
No.
documents or wrong reference has been made to wrong questions. Well, I was just addressing your lordship on no demand.
We hope those are not available till the matter goes up to the Supreme Court and the matter is decided. If those are discovered after our judgment, whichever way it goes, and then those are placed before the Supreme Court, then now
No,
the directions nowadays being passed by the Supreme Court, Mr. Shah, we have forgotten what we are. I saw a video today. I mean, so that will be circulating soon
Yes.
about a judge, High Court judge. Anyway, let's.
Whatever,
We
ultimately-
were actually watching that during the
I see.
break.
I'm sure, we will get our turn will come next.
Don't know what is happening. No, not. I mean, we cannot discuss it here.
Ultimately, one looks at the institution and not at the.
Even outspoken judges have their limits. We should not discuss this here.
Yes.
So
Sometimes the less said, the better.
no, less said the better is absolutely a motto now.
Then your lordship, please have a look at here. Reference is made to these documents saying that there were demands made from time to time. And there is reference particularly to letters of 14th October and 19th November.
Yes.
And then paragraph 85. Irrespective of the above position, again, it is a contractual obligation of the seller, being the respondent here, to supply the goods under the contract, irrespective of any demand made by the purchaser, being the claimant. The supply of the respondent in any event does not and cannot depend on any specific demand made or not made by the purchaser, being the claimant here. Respondent is bound to fulfill its contractual obligation under the contract by supplying goods to the claimant, subject to fulfillment of the reciprocal obligation. Well, just pausing here for a moment. Well, payments for supplies made up to June made in full. Well, further, advance payments made for supplies during the currency of the contract not paid. Now, that advance payment is in itself a demand. It manifests a demand. And the important part is, ultimately, your lordship will see that much has been said about 7,000 metric tons a month. But in none of these arguments, or even in the defense statement, has it been said that you have forfeited a right to the goods which you have not lifted during the particular month. That is not the case. Then one more paragraph here. At paragraph 86, that the obligation to supply the goods under the contract by the respondent cannot be diluted and or denied merely by taking the plea that no demand was made by the claimant for such supply. Such plea under submission is absurd under the provisions, etc. Appears from the pleading and the evidence of the respondent that the respondent, in fact, at different places has taken different plea for non-supply of the goods. In some place, it has stated that supply was not effected because of non-payment of 100% advance, whereas in some place, it has taken the point that claimant did not participate in the tender. Again, in another place, it has taken the point of non-availability of the goods with the respondent, and finally, it was stated that no demand was made by the claimant for the supply. In answer to question 38 by the respondent's witness in cross-examination, however, stated that the competent authority had taken decision to stop supply because of long outstanding dues. Witness does not refer to any other ground in his answer. Even if we take this answer of the respondent as correct, it is not so factually, because the claimant had made full payment for the supplies which were made up to June 2004, which may be delayed, and had also tendered the payment towards future supply to the extent of 3 crores, which checks were ultimately returned by the respondent on the ground of non-participation in the tender. So, therefore, even the final stand which has been taken by the respondent's witness in answer to question 38 is grossly contrary to records.
Mr. Shah, the demands which you have made, the correspondences which have been referred to, none of those specifically say that supply this much amount to me or specifying the amount.
No.
Not that.
No.
So if you did that, then they might have said that yes, specific demands were made at instances.
No, my lord, no specific quantity was ever, my lord,
So
at least
therefore,
I
that
have not been able to
that
identify.
apparently supports your argument that the demand was not a prerequisite.
That's it.
I mean, you have whenever short supply was given or deficient supply was there or defective supply, we had pointed out that we require more and you are not giving general terms.
And my lord, here ultimately, my lord, even after this, my lord, interregnum, my lord, period of dispute with regard to quality, my lord, in October and November there are demands made, maybe not of specified quantities.
Yes, because during the period when they supplied from March to June, during that period also we don't find apparently any specific demands being made by you.
I have not come across.
Because those have not also not been referred to. If not referred to, then for those periods, Mr. Dutt will answer that their claim may be defeated that specific demand was a prerequisite. Because if they have supplied without demands, without specific demands, supply me this much and I am supplying.
It is not on record, my lord, that much, my lord, I can
May
say.
have been there, may not have been there, but not discussed anywhere.
I have no recollection of what happened in the arbitration. It was quite a long time
obviously.
back. I am sure Justice Sen might have some recollection, but my lord, I am not sure about that.
Who was there?
Justice Showman Sen.
Oh,
He was my lord.
that is the Mr. Shen referred to.
Yes.
So the food must have been very good there. The sessions.
Now, my lord, the last point, my lord, with regard to delay in making payment, my lord, which has been canvassed by the respondent also, that your lordship will find discussed from paragraph 88 onwards.
Yes.
It has already been mentioned above and has also been admitted by the witnesses of both the parties that against supplies made by the respondent between April to June 2004, part payment and or ad hoc payment were made from time to time, and finally the balance payment was made by letter dated 30th December 2004, being documented page such and such. The question reasonably arises as to why there was a delay to make such final payment. In answer to that, the claimant's witness, Ajay Kumar Tatia, in answer to question 179, stated that although the ad hoc part payment was made from time to time, but the balance payment was withheld since the question of complaint with regard to inferior quality of goods was pending with the respondent. However, such balance payment was made because of a threat made by the respondent by its letter dated 24th December 2004 at page 81 of the brief of the document. It is also a matter of fact to be noted that until 24th December 2004, there was no demand for such payment of such balance sum made by the respondent. As discussed above, while we were dealing with the issue of rejection of the goods, notwithstanding the fact that written complaints were made by the claimant about the quality of the goods and for inspection, etc., respondent did not give any reply. Malad, kindly take note of the fact that there was no written demand for payment of this balance, Malad, till 24th December 2024. Therefore, quality dispute with regard to the quality aspect was kept pending, and the claimant was under reasonable impression that there would be some sort of arrangement between the parties with regard to either diminution of the price of the goods or adjustment of the price, and on such presumption, the balance payment was not made. However, the ultimate payment was made, and that was also accepted by the respondent without raising any objection. Therefore, in view of the above discussion, we come to the final conclusion that the respondent had committed breach of the contract by not delivering the remaining quantity of the goods under the contract to the claimant. Now, my lord, hereafter, my lord, it is a matter of, my lord, the claims. Now, so far as the claims are concerned, my lord, the first claim that was made on account of substandard quality of goods, that was rejected. My lord, some of the other claims have been allowed. My lord, please first, my lord, see the summary of claims that have been allowed and rejected at page 140 in volume 1.
Yes.
My lord, claim 1, my lord, which is for the excess amount spent in purchasing 47,413.70 metric tons. My lord, that is, my lord, allowed. Claim 2, my lord, which was on account of substandard or inferior quality of goods, that is rejected. Claim 3, my lord, which is on account of, my lord, loss of profit, my lord, calculated at 15%. My lord, that is, my lord, rejected. That is allowed, I'm sorry. And my lord, claim for loss of goodwill is rejected. So, my lord,
No,
really two claims
where
are
is that
relevant.
component that the difference between the amount you purchased?
That is, my lord, claim 2. Claim 3. I'm
Okay.
sorry, claim 1. Claim 1.
Oh, yes, right. Yes.
Claim 1 is the difference in price.
Yes.
Claim 3 is the loss of profit.
Right.
For the balance not supplied, claims 2 and 4 are rejected.
Inferior rejected and goodwill.
Yes. Goodwill rejected. Now, my lord, coming to the question of my learned friends, my lord, assertion, my lord, before I go on to the quantification of the claims, my learned friends assertion that, my lord, A, there was no obligation to supply. B, you had to participate in tender. C, there had to be 100% advance payment. And D, in any case, you did not come forward to make payment of the price, it was left outstanding. My lord, all have been elaborately dealt with. Now, my lord, comes to the question of waiver, on which my learned friends have cited authorities. My lord, I have shown your lordship section 63. My lord, section 63 is, my lord, something that can be implied from the course of conduct of the parties, and that is how the tribunal has proceeded. Now, my lord, the question is, my lord, even if,
yes,
my lord, your lordship sees the award, my lord, here the tribunal has taken into account all possibilities. Say, even assuming that there was no waiver, ultimately you've made payment of the entire supplies made up to June. And for, my lord, the rest of the supplies, you had made an advance payment, but this was returned. So, my lord, the question of waiver never really surfaces. And secondly, my lord, what is very important is, my lord, here, my lord, your lordships know that now, it is, my lord, quite completely well settled, that, my lord, a wrong appreciation of a law, unless it goes to the root of the matter, is not ground for, my lord, interfering with an award. That is order for 34 Rule 2A. Although, my lord, this was ultimately incorporated in statute book in 2015, this principle has been, my lord, followed. So, my lord, unless it is, my lord, a fundamental, my lord, principle law which, my lord, violates the public policy of the country, fundamental policy of law of the country, my lord, one should not, my lord, look at it very strictly. Now, my lord, the question is, of course, my lord, are the views that have been taken, my lord, possible views? Or is it something that, my lord, no reasonable person could have reached at all? That is, my lord, the test which your lordships have laid down. And, my lord, I would, my lord, defer to the tribunal and say that, my lord, right or wrong, they have, my lord, dealt with each of the points, my lord, with, my lord, sufficient logic and clarity. One can't say that, my lord, this is perverse by any stretch of imagination. Now, my lord, coming to, my lord, the other parts and parcels of, my lord, the claims, my lord, it's your lordship's pleasure that, my lord, should
We'll
I
continue? Yes. We'll continue after recess.
After recess?
You have some difficulty?
I will have some difficulty.
You're almost done. No,
My lord,
you
no,
cite
the
that.
second matter, my lord, is completely left.
Oh,
undealt.
different flavor.
Yes. Well, I am a little embarrassed, but, my lord, on the 12th, if your lordships take it on any other day, my lord, 11th and 12th, I'm in some difficulty.
Yes, then Mr. Dutt, if you don't have any objection, to keep it on 19 then for further review.
How can I?
You never have any objection.
No, Mr. Dutt is, my lord.
Sometimes have objections. Still close arguments here then.
I will, my lord, I will not take much time, but I still need about an hour's time.
You'll have to wrap up.
Yes.
So very well. Hard in part. The matter is adjourned for further hearing till August 19, 2025, when it will be listed under the same heading.
Great, grateful, man, very grateful.
That your lordship would be continuing with this list because Mr. Jointo Mitra was inquiring of me.
Yes, we'll continue.
So I'll tell him that your
Yes. Now he will come.
I'll tell.
You are there in that.
Mitra is there.
Mr. Mitra is hiding behind the juniors. If all could be in the back row like you, Mr.
No, my he is omnipresent. So, my lord, does not
He's
matter where he is.
Omni in Bengali as well as in
Yes.
English. So very well. So we'll take up Mr. Mitra's matter after recess. The first thing.
Your Lordship, yesterday's item number 57, you are instructed for submitting the written notes of argument.
You are filing that?
Yes.
আমাকে দিচ্ছেন কেন? হ্যাঁ কপি দিয়েছেন তো? Not 2 copies?
No, only 1 copy.
Single bench সেটা তো ডিভিশন বেঞ্চে সেভ হয়েছে 2 judges 1 copy.
Okay, I'll file.
You assume that one of the judges will not do anything. So give another copy. ফেরত দিয়ে দিন, ওটা দিয়ে দিন। Give it after recess, ma'am. Don't have to mention it. ওটা আপনি ফাইলে পাঠিয়ে দিন।
Milord, I am for the respondent, Milord.
Right.
I am filing the opposition, Milord.
Pardon?
I am filing the affidavit in opposition, Milord.
There was a direction previously.
Yes, Milord.
We are at the final hearing stage. Affidavit to what?
They give reply and we have.
But we have made an application in the appeal because we were not party to the suit.
For getting
My lord, after the suit was dismissed, my lord, the property was transferred because, my lord, what happened is, your lordship sees.
Mr. Mitra, before we start,
Yes.
We would like to put it to you that the council appearing she has personal stake in the matter, so we know her.
Yes,
So if you have any objection, we will not take up the matter.
Milord, yes, Milord, we have objection, Milord. We have
To our taking up the matter,
Yes, Milord. To proceed the matter, Milord.
not that.
Oh, Milord.
No, we know her personally.
Okay, Milord.
So
Okay. Milord,
because
Milord want to
she
release
was
the matter, Milord. Milord want to release the matter, Milord.
no, we are not wanting to release the matter. We are putting a question to you
Milord.
because the difficulty is because she's an advocate. Most of the judges know her,
Milord,
so she'll not get they'll not get a bench.
Milord, Milord.
So we put it to you whether you have any objection because we know her as a professional.
Milord,
Because she's personally
Milord,
involved.
what Milord deem fit, Milord, Milord, do it, Milord.
If you have any specific objection, if you have any instruction, then take it. Then we'll consider.
Milord, may I take instruction, Milord? It will be best, Milord. From
Take instruction. Let us start the matter. Take instruction from your client right now.
Milord, my client is not here right now.
Phone
Milord.
call away.
Milord, may I help you in this matter, Milord?
Mr.
Milord,
Dutta, you are appearing
yes,
in
yes, yes. It is
the other side.
it is my personal matter, Milord. I have engaged Mr. Ajay Maitro. He's for some medical issue. He didn't come today. Milord, objection of affidavit in objection and supplementary be taken on record and next Tuesday, Milord, for taking a hearing, Milord. Because
No,
he
Mr.
paid for
Dutta,
one
we are
side.
saying you are for one of the sides. Your friend is for the other side. So both of you, we know. So if neither of you have,
I have no problem before your lordship take up my matter, Milord.
Very well, because we know both of you. So
Yes, yes, Milord. On previous occasion, I have
bias,
no
the
law point
bias,
has to, law point has to be decided.
the bias if it is counterbalanced, Mr. Dutta.
No, Milord. I am pure confident before your lordship, Milord.
Also, may I have a leave to file a supplementary affidavit where I want to disclose one.
Have you given a copy to them previously?
Yes, Milord. Advance copy has been served, Milord. Yes, Milord. Advance copy has been served. Milord, if they want to give reply on that, Milord, they.
Very well. So we'll take that. They're not you file your whatever documents you have. Affidavit in opposition and affidavits in opposition and reply filed today be kept on record. Full on the prayer of learned counsel for the respondent, leave is granted to the respondent to file a supplemented affidavit, whose copies thereof have been exchanged previously between the parties. Whose next para? Since we know the how is she related in the matter? You are trying to intervene.
Yes.
Since we know both,
we are the applicant in this appeal. We are not in the trial.
Since we know both the applicant as well as the respondent, and we put the question to both of them as to whether they have any objection in our taking up the matter on such ground, both sides express their agreement to us taking up the matter. Accordingly, we take up the matter for hearing of the application.
Very good. Yes. My lord, we have a lordship's leave to my lord file affidavit in reply, to which my lord they have given the reply. This is the affidavit in reply. Copy has been served now.
So first we are hearing the application for intervention.
Yes, sir.
Well,
Lordship will please.
Mr. Dattu will be appearing himself by.
No, Milord. In this matter, I have engaged with Ajay Maitro.
Ajay Maitro
come today for medical issue.
For medical,
convenient not
he's
today.
not here, Milord. So
medical issue,
it is.
Yeah, medical issue. Some.
So, Mr. Dattu, you are online, appearing online. So, what is the difficulty?
Milord, already I have given. If your lordship desires, I have no problem.
Let us, because the difficulty is these are.
I can point out only one point, but this appeal is abated. Kindly consider.
No, we'll hear you on merit. No difficulty.
All right.
Let Mr. Mitra start the matter. Let us see what.
Yes.
Yes, Mr.
I can see the same man. Also,
What is your stake in the matter? So this is an application for leave.
Yes, but I
You
tell
want to-
you, Lordship, my lord,
Yes.
this particular property is to be owned by Nico Corporation Limited.
Yes.
Now, Nico Corporation, my lord, went into liquidation under the my lord, IBC, IB code. And my lord,
CIRP has culminated
yes,
in approval
and my lord, yes,
and your purchase.
and my lord, the property has been sold by
Resolution
yes,
profession.
and my lord, I am the purchaser of one floor,
One floor, which is the subject matter of this.
which is the subject matter of this.
So, Mr. Datta, we have to add her because she has stepped into the shoes as far as the first floor. So, we are allowing this application and we'll take up the appeal.
At first, amendment point should be decided because appeal is awaited. Kindly consider that issue.
Mr. Datta, since it is an Order 22 Rule 10 scenario, this Order 22 Rule 9 does not apply.
Yes, Order 22 Rule 8 is applied here. Already awaited because the liquidator appointed in 2017. And now they are filing the application for substitution 2020-25.
Death of a company, of a juristic entity.
No, that is a judgment of the Honorable Supreme Court.
Order
But I am
22
just
late.
asking,
That's right. Let us just consider that.
uh, 2010 8 SCC 685.
Acha. So it is the other way around, Mr. Datta. Rule 8.
Until and the setting aside of the amendment is complied with, no hearing can be taken up on merit.
The insolvency of a plaintiff in any suit in which the assignee or receiver might maintain for the benefit of his creditors shall not cause the suit to abate unless such assignee or receiver declines to continue the suit.
That's right.
Yes.
So to the contrary, they are wanting to continue the suit. So
No,
the scope of
liquidator didn't continue in this matter. Kindly see my supplementary affidavit on which
it
date
would not
he has
abate.
appointed.
Would not abate. It's the other way around, Mr. Datta. It continues. It does not abate unless they say that will not continue with the suit. Declines.
Yes, he is declined here.
They're not declining. They're wanting to add it as parties.
No, liquidator has declined. He subsequently came before this picture.
No, there's
He
no
is a third party.
abatement. No abatement at all.
Yeah,
Unless they come and say that we
the
don't
judgment
want to
in this
proceed.
2010 8 SCC 685 is completely covered.
Have you got a copy of the judgment here? Junior must have a copy.
I have not.
2010 8 SCC 685.
2010.
2010 8 SCC 685. It's completely covered this matter.
But you should have furnished copies of that.
Yes, I actually today I asked for praying for adjournment, Miller, so that.
Yeah, difficulty is that we have, the senior who is leading me is not well. So today we prepared our mind to pay adjournment on
Sufficiently
that ground.
prepared. Mr. Datta is always prepared. You have never seen him unprepared.
Milord.
Give us half a minute to just find it out.
Paragraph 7 is the relevant paragraph.
Yes, we'll be presently coming to that.
Yeah, I'm researching it. Correct. Being on record that 3 times. You see, abatement.
Which paragraph?
My paragraph starts from the counsel appearing for the applicant while relying
Number
upon
of the number of the paragraph?
As per my site, he reported 7, paragraph 7.
Paragraph 7.
Counsel appearing for the applicant while relying upon the judgment.
Yes.
That's paragraph 13 in the SCC online copy.
Oh, that is something different. Can you see the paragraph?
This is regarding Order 22 Rule 9, Mr.
But prior to that, 8 is applicable, then 9. Otherwise, it cannot be taken up. Already awaited. Already awaited.
All right, we will decide that first. We are deciding that point first, then we'll go.
May I read out?
Yes,
It once the appeal or suit is abated, unless it is setting aside the abatement, matter cannot be taken up for hearing.
cannot, definitely.
Yes, that is the point first.
So we are deciding this point first. We are deciding.
Yes, that is the first point. Otherwise, matter cannot be taken up on merit.
No, right now we are deciding. So we have heard you, Mr. Mitra, on this.
Lordship, I didn't understand this, how it is applicable.
This judgment? Yes, one copy. Thank you. ওনাকে আমার তো আছে at the outset, comma, an objection as to maintain the brief backdrop of the Mr. Mitra, please take your seat, both of you. The brief backdrop of the present application is that the appellant company, comma, namely NICO NICCO Corporation Limited, comma, underwent a corporate insolvency resolution process under the Insolvency and Bankruptcy Code, comma, which culminated in a resolution plan being approved. Full stop. Pursuant to the same, comma.
Well, no resolution plan. This is in liquidation.
On liquidation. আচ্ছা, নিকো কর্পোরেশন লিমিটেড যেখানে বলুন তারপর থেকে কেটে দাও বাকিটা went into liquidation and, comma, within the under the provisions of the Insolvency and Bankruptcy Code, comma, sale was held of the assets of the company, and the first floor of the second floor of the suit property, comma, which is the subject matter of the present litigation, was purchased in such liquidation sale by the present applicant. Full stop. Next para.
One point. He is not the original auction purchaser. He is the subsequent purchaser. Auction purchaser is not the applicant. Narolia Financial Limited is the auction purchaser. He is the subsequent purchaser.
Your Lordship will be pleased to come to page.
You are not the original purchaser.
Yes.
Of course, sir. Kindly come to page 9. Okay. I don't know why all these points have been raised. Kindly see.
In the e-auction process, he didn't participate.
Page 9 of the application.
Yes.
Deed of conveyance dated 26 September 2019. NICO Corporation. And turn over the page. Kindly come to page 14. And kindly see,
Liquidator?
Represented by liquidator? No. Page. This is the application. Petition. This is scan 2. Page 9, my lord, the conveyance starts at page 4.
Yes, Mr. Datta, page 14, she is the purchaser.
No, my lord. Actually, what happened? He is not participated in the e-auction process, but there was a consortium. The Narolia Financial Advisors Limited is the original auction purchaser. Subsequently, he has purchased from him and he was the assignee. That was the fact. The e-auction process, I have the chart, only the Narolia Financial participated. He didn't participate in the auction process. That is 100% sure. Subsequently, he purchased.
Kindly come to page 42.
The applicant didn't participate in the e-auction process.
Above referred to. These are the persons who purchased through the consortium. Details of the consortium, see. The second schedule, details of the consortium. And my lord, these are the purchasers. Item 3, my lord, kindly turn over the page to page 43.
Yes.
Page 43 top.
Yes.
They are the purchasers through the consortium. and they have paid the money. And that is why conveyance has been executed in her favor.
Purchase the কি বললাম? Purchase the property. By the applicant as a part of the consortium. Full stop, next para. Subsequently, comma, the present application has been filed, comma, seeking leave to for the applicant to proceed with the appeal in place and stead of the original company, comma, which has since been liquidated. Full stop, next para. Learned counsel appearing for the respondent seriously opposes the application and submits that the applicant was not the original purchaser of the property. Full stop. Learned counsel cites the judgment of Balwant Singh versus Jagdish Singh and others reported at 2010 8 SCC 685 for the proposition that once a suit is abated, comma, unless the abatement is set aside, comma, the suit cannot be proceeded with. Full stop. It is submitted that the same principles apply to an appeal as well. Full stop. Next para. Upon hearing learned counsel for the parties and on a perusal of the purchase deed of the applicant annexed to the application bearing Can 2 of 2025, comma, we find that the applicant was a part of a consortium and purchased the present suit property. Full stop. Next para. In view of such registered sale deed, comma, the applicant, comma, thus, comma, has become the present owner of the suit property and as such, comma, has stepped into the shoes of the company. Full stop. Next para. Insofar as Balwant Singh's case supra is concerned, comma, the same pertains to a case where a suit is abated and refers to Order 22, Rule 9 within bracket 2 and within bracket 3 of the Code of Civil Procedure. Full stop. Rule 9 of Order 22 contemplates a situation where a suit has abated or is dismissed under Order 22, comma, in which case no fresh suit shall be brought on the self-same cause of action unless the abatement is set aside. Full stop. Next para. Learned counsel for the respondent also relies on Rule 8 of Order 22, which provides that the insolvency of a plaintiff in any suit which the assignee or receiver might maintain for the benefit of his creditors, comma, shall not cause the suit to abate, comma, unless such assignee or receiver declines to continue the suit. Full stop. Next para. It has to be noted that there is a distinction between the demise of a biological person, comma, and comma, biological person and a juristic entity. Full stop. In case of the latter, comma, no demise takes place, but the substitution of the person who steps into the shoes of the juristic person is governed by Rule 10 of Order 22, comma, since there is a devolution of interest. Full stop. Next para. The concepts of Rule 3 and Rule 4 of Order 22 are, comma, thus, comma, not applicable in such context. Full stop. Next para. Even on a plain reading of Rule 8 of Order 22, comma, the law is clearly laid down to the effect that there shall not be any abatement in case of insolvency of a plaintiff by default, comma, unless the assignee chooses not to continue with the suit. Full stop. The clear language of sub-rule 1 within bracket of Rule 8 of Order 22 makes it abundantly evident that the suit shall not abate unless the assignee declines to continue with the same. Full stop. In the present case, comma, by the act of filing the present application for substitution, stroke leave to continue with the appeal on behalf of the company, comma, the applicant stroke assignee has made it clear that she wants to continue with the suit, which of thus, comma, even within the contemplation of Order 22, Rule 8 of the Code of Civil Procedure, comma, it cannot be said that the suit has abated in any manner. Full stop. Next para. Rather, comma, under Order 22, Rule 10 of the Code of Civil Procedure, comma, in case of an assignment, comma, leave ought to be granted to the applicant to continue with the appeal by stepping into the shoes of the original appellant stroke company. Full stop. Accordingly, can 2 of 2025 is allowed, comma, thereby directing the applicant therein to be added, to be substituted in place and stead of the original appellant hyphen company, and leave is granted to the applicant to continue the appeal. Full stop. Next para, there will be no address to cost. The necessary corrections in the cost title of the memorandum of appeal shall be carried out. Memorandum of appeal and the paper book shall be carried out by the learned advocate on record for the applicant by tomorrow.
One point, Milord. There
Pardon?
is about 6-year delay. Assuming the substitution is allowed, there is about 6-year delay.
This is not a substitution under 22 Rule 9. There is no abatement at all under Rule 8, as you rightly pointed out. If there is no abatement, there cannot be any setting aside. So there is no delay at all.
In case even if a substitution, that would be a delay. All right, your lordship decided already.
Yeah,
The main matter will be taken up, Milord, next day, Milord.
Next day?
Yes, Milord.
Mr. Dotto, let us start hearing Mr. Mr. Mitru will not hear you.
My conducting lawyer will be present on the next day, Milord.
Your conducting lawyer is there?
No, he is not, Milord. My senior, Ajay.
He is a non-conductor.
One part is over. Let me decide whether.
Mr. Mitru, what do you say?
Well, may I just indicate the point your lordship will kindly attend, because I don't want to stand in the way. My learned friend has got a senior in the matter.
Yes, Milord.
And,
Who is appearing with you?
Yes, Ajay Mitru is leading me, Milord.
Means Ajay Mitru?
Ajay.
He has not come to court?
Yes, Milord, due to some medical issues.
Oh, achha.
That is why, Milord,
Yes, Mr. Mitru, you can start the point. Mr. Dotto will not be taking up the matter. Let Mr. Mitru just indicate the point and we'll keep it as part and it's in any event assigned to us. So
yes. What you will be pleased to, my lord, take just the plaint and the impugned judgment. I am not going to place anything more, my lordship.
What is the impugned judgment?
My lord, the impugned judgment, my lord, in ex parte, the plaintiff, my lord, proceeded ex parte in the matter because the defendant did not appear. But the suit was dismissed.
Suit for?
Suit for possession.
You failed to prove your case, Master.
Well, I have not come across this proposition of law.
Could we look at the judgment first then?
Yeah, kindly look at the plaint first, then it will be easier for your lordship to understand the judgment. Because the whole thing is on the basis of the plaint. Kindly, my lord, come to the plaint first. This is not at page 2 of the paper book. Your lordship kindly comes to paragraph 2. The defendant's 88 square feet on leave-in license basis on the second floor. Well, I'm not troubling your lordship. 4, para 4. Considering the relationship with the defendant and the plaintiff's senior officials, the plaintiff agreed to demise on license the said premises to the defendant under an agreement for leave-in license dated 18th August 2005 on the terms mentioned here. Then para 5. This is the most crucial paragraph on which the reliance is placed. The defendant has never been in exclusive possession and never has the control over the said demise premises, usual pleading for the purpose of license. The premises was always locked by the plaintiff's security guards and the defendant never had uninterrupted possession. The defendant also did not complain of the same. Then in terms of the leave-in license agreement, the defendant has made security, etc. Then upon expiry of the first 11 months, at the request of the defendant, the agreement for leave and license has been renewed for 2 further periods of 11 months each. The defendant had always represented that it was in the process of purchasing an office space but required further time. This has been accepted by the plaintiff and the amicable.
Mr. Mitra, is there any scope of construing the live-in license agreement as a lease agreement?
Well, kindly similar what the judgment is. That particular paragraph 5 has been relied upon for the purpose of saying that since the plaintiff has pleaded that it is in possession, in control of the portion, therefore, my lord, he doesn't need any. There is
No eviction is required.
no eviction is required because he is all. Kindly, my lord,
Why two appeals, Mr. Mitra? Two appeals?
I see. Two different places. Well, perhaps you lot.
So both are on the second floor because we said second floor.
Yes, both are on the second.
Let us see the judgment. We can't wait to see
Judgment
the
is,
judgment.
my lord, at page 18. Summons has been served of a third paragraph, and the defendant also entered appearance in compliance of the summons. But thereafter, he has not turned up to contest the suit, and therefore the suit is heard ex parte. During hearing of the suit, one Kartik Kumar Chatterjee, the president of the plaintiff company, has filed affidavit in chief, which is kept on record. He has also got himself examined as PW1. The documents are admitted into evidence on his testimony and are marked Exhibit 1 to 5, as detailed in the list of documents kept in the record. The plaintiff's case is that the suit premises described in the schedule to the plaintiff belongs to it, and the defendant was inducted as a licensee to the premises on 18/8/2005 by virtue of an agreement executed by and between the parties for about a year. The defendant also made non-refundable deposit of rupees 42,240 and also a further sum of rupees 42,240 refundable interest-free deposit with the plaintiff company. The license was renewed also from time to time since the inception, and the last of all, it was renewed on 1/8/2007. Thereafter, the license of the defendant was terminated by the plaintiff company by two letters.
We have read the judgment, Mr.
Your lordship sees.
We have read the judgment.
So, what? But I don't know.
So what is the error in the judgment? Just go and enter. Mr. Datta, come well prepared. Ms. Mitra will come. There. There will. Yes. So we have heard you. If you want to cite any judgments on this, then we'll feel ashamed.
Well, I don't know what judgment I should cite on this. The court had said that because I have pleaded in paragraph 5 that, therefore I don't need any possession. I am already in possession, therefore no, this suit is dismissed.
Third learned senior counsel on the appeal. For further arguments on the prayer of the respondent, let the matter stand adjourned till August 12, 2025. Mr. Datta, please ensure that Ms. Mitra is there on the next occasion.
If he is unable, I will complete it.
Fair, fair. Thank you. Thank you so much.
না যদি আসে আমার কাছে আমি তো করবো definitely if there is any possibility of settlement.
Milord, supplementary affidavit was filed, Milord.
It's on record. That was the first line of our order.
Milord.
All affidavits are kept on record, including supplementary.
Yes.
Yes. Yes, 7.
Then Milord, I appear on behalf of the plaintiff respondent.
Yes. Assignment.
That assigned with your lordship because
this matter is assigned to us.
the earlier the honorable division.
So this is a broken bench, and we sat only to take up our part of matters.
That's why we mentioned with your lordship earlier. Your lordship said the question of the can be formulated by the services against single judge. We mentioned the matter before Justice Day. The Justice Day said that because of the division bench that formally admitted the appeal, but the point of question of law, it is left, so the let be aside. So his lordship.
So this is only for the purpose of formulation of a question of law.
Question of law.
Mr. Chaturvedi, you don't have any right of hearing.
The division bench also observed if at all.
Because it's the first formulation of question of law. It's the division bench.
I was relying on a decision, very recent decision of the Honorable Supreme Court, to the effect that if there is no formation of opinion that there exists.
So we'll rehear the application and order for 11. It's virtually there.
For admission.
Yes, it's virtually there.
Unless the question of
you're right.
Because although there is an endorsement of the Honorable Division Bench, Coordinate Bench, on 17th January 23, saying that we
admit the appeal, formally admit the appeal.
What is that order?
17 January 2023. But at that time, the Honorable Division Bench was following the practice of serving the copy. And there was also initial order of injunction. Thereafter,
there are several such matters where
the Honorable Division is just following this practice to serve the copy and then hear the respondents on the questions.
save us the embarrassment of recalling this order and give us solid questions of law. At least one will
I have.
that Mr. Chaturvedi doesn't have to stand up.
That I shall try, my lord. This is question of, it's a judgment of reversal. The trial court, my lord, trial court, my lord, distinctively held on the basis of the commissioner's report. And
you are the plaintiff.
I am the defendant.
Defendant in a suit for eviction.
No, this is this declaration and permanent injunction. The claim of the plaintiff is that the plaintiff was not enjoying a passage on a western side of the of a plot of land, and on which the allegation is that we have not encroached and we have constructed the boundary wall. That is the allegation. Now, at the initial stage, the trial court, the trial court took pain to go into the details of the matter after the considering the schedule and the commissioner's report via the report that came to a finding. There is absolutely the description of the suit property is vague. It's not in compliance with Order 7 Rule 3. Number one. Number two is that BLRO, the plaintiffs also filed a proceedings under Section 145 of the CRPC 147, in which BLRO report was called for. BLRO report also says that there is no existence of that passage. And the commissioner also...
That BLRO report was exhibited?
Yes, it was exhibited. And the commissioner's report also corroborates with the fact that there is no existence of that particular...
Commissioner was appointed in this suit.
Yes. And the learned first appellate court totally reversed the findings based on the same commissioner's report. Although the description of the suit property, learned appellate court also recorded there is a doubt regarding the existence of that plot. May I just summarily just point out those portions? Kindly comes to the learned trial court's judgment, running page 2.
Let us start with the appeal court judgment, Mr. Rajesh.
If your lordship kindly...
in your own.
It is
trial court which page?
The trial court running page 2. That is second certified copy.
Page 2 of that. Yes.
But kindly bear in mind that the plaintiff's suit plot is plot number 1946.
First, let us have a look at the schedule.
Page 2. Page 2. Page 2.
The degree is there. We just.
Page 2, second schedule. The passage is shown to be at the western side of the Schedule 1 land, which is part of plot number 1946.
No, they want eviction from Schedule 2.
Schedule 2.
And Schedule 1 is the entire property and 2 is a part of that.
1946 is one plot of land.
So why 2 schedules?
Schedule because the plaintiff says that 10 decimals out of 13 decimals she is possessing. The 3 decimals is possessed by the defendant number 2. Defendant number 2 is possessing 3 decimals. Total plot 13 decimals here out of that. Now plaintiff says that within that 10 decimals, along with the 10 decimals land, she has purchased the right of user of 3.5 feet common passage, which is according to the plaintiff is western side, according to the schedule it is western side. Now this is the deed is examined by the learned trial court, and the allegation is that defendant number 1 raised a wall on the northern side of the suit property. Mine that kindly comes to firstly, the issue number 8, running page number 6. There the trial court recorded the plot numbers and others, and kindly comes here. The evidence also of the plaintiff kindly comes to page 7, second paragraph from the bottom.
Yes.
A perusal of the sale deed such and such does reveal that the previous owner of the suit plot such and such had indeed given the purchaser Pushparani Devba the right to use a passage along with sale of 10 decimals of land to her. So passage is not within 10 decimals. Along with that, now in where this plot is, this passage is like...
Total property is 13 decimals.
13 decimal total. Plaintiff is possessing 10 decimal. Defendant number 2 is 3. I am in total separate plot. Adjacent plot, separate plot. That is plot
He's
number.
claiming easement right over your passage.
No, she is saying not. She is not exempt right by the right title interest by the deed. Although deed does not include that plot number in which the passage is mentioned. She is saying that along with 10 decimals long, the original deed shows that another passage of land 3.5 feet wide.
So out of that 13 decimals,
that does not exist. That's why
he purchased out
10
of that
decimals.
13, she purchased 10 decimals.
Then defendant number 2 purchased 3
Does she say that this passage is within that 3, rest of the 3?
No,
a different plot.
Different plot,
Which
plot
is
number.
yours?
Yes,
Exclusive.
not mine. Another person's.
Achha.
But that is there.
So
just second paragraph.
You are who are you?
I am the owner of plot number 1943, western side plot.
So she is claiming the passage on your property then?
No, she's claiming
that
as if I have encroached upon her land and built up the blocked the passage by boundary wall.
You have produced your title deed.
Yes, absolutely. There's no kindly bear it for 2 minutes, plot.
Yes.
This is the perusal of the deed number does reveal that previous owner of this plot number such and such had indeed given the purchaser right to use a passage along with sale of 10 decimals. So passage is not included within 10 decimals. I must mention here that no plot number of the land through which the such passage passes has been given in the said deed. A mention must be made that the total area of the land suit plot is 23 decimals in the said deed. Plaintiff has claimed that such right of use the passage was transferred to him legally under her title deed, Pushparani Devba. A perusal of the deed content shows that her vendor has mentioned a specific plot number 1947 as the land through which the plaintiff was given the right to use as a passage. Plaintiff Jyotsna Chakraborty, being cross-examined PW1, has stated RS plot number 1947 of Horipodo Chakraborty lies as the eastern side of the suit plot 1946. Thus, the exact location of the suit property as a passage as per recital in the plaintiff's title deed and the plaintiff's statement as the above appears to be at the eastern side of the suit plot. However, suit schedule depicts the schedule of the suit property at the western side of the suit plot. Thus, given inconsistency, it would be incorrect to assume that the depiction of the suit property is ambiguous. At the time, argument and a lawyer defendant submitted that the suit is vague and interest. So this is not one point that the suit property is not, schedule is not distinct. It is vague. Kindly comes to the commissioner's report, which is dealt with. Page 9, BLR report and commissioner's report. Page 9, next page. Determination of the previous issue. The next issue is whether the plaintiff has right title interest and whether defendant number 1 raised the one. That's the 2 issues framed. Now the page number 9. Determination of the previous issues whether issue number 8 has revealed that the description of the suit property is quite vague without any proper details of identification of the same. In filing the suit, plaintiff has claimed her right to use the suit property as a passage for ingress and egress of the village Kudi Road from her purchase portion of the suit plot. It is not the case of the passage is the only pathway to reach her plot from village Kudi Rasta. A perusal of the sketch map given by the plaintiff in the suit schedule shows that one face of the plaintiff's purchase plot in the suit plot lies adjacent to the village Kudi Rasta. Thus, it appears that the passage, if any, is not the only point for ingress and egress to the reach of the plaintiff's plot. Besides, the plaintiff has remained completely silent regarding the use of suit plot property for the purpose of ingress and egress. There is no recital in the plaint regarding the plaintiff having used the passage after acquisition of the suit plot. In fact, the evidence of her witness also are quite mute in this respect. In this respect, reference may be made to the report of the local investigation, which is marked such and such. Learned Pleader Commissioner has mentioned the boundaries of the suit plot at page 7 of the report. He has reported that the village Kudi Rasta lies at the north side of the suit plot, another Kudi Rasta at the south side, RS plot number 1947 at the east, and RS plot number 1943 and 1945 boundaries such and such. Thus, it is clear therefrom the suit plot RS plot number 1946 had Kudi Rasta at its northern southern side. He also mentioned in his report that he found a very old high brick wall that was earlier at the western and eastern side of the plaintiff's building. Learned Pleader further reported that he did not find any passage in the western side of the RS plot. That is the schedule.
How did the appeal court reverse?
The appeal court also recorded. But kindly see that there is no doubt regarding the existence of the road. Kindly comes to running page 4. No, running page 21, I'm sorry. Yes. Kindly comes to running page 21. That there are other issues, raised judicata and other things. I am not disputing, not raising that. Finally comes to that page 21, second last paragraph from the bottom. Therefore, it is clear that owing to raising of a wall by the respondent defendant number one over the suit property, that wall was old brick wall. A cloud has been casted over the existence of the passage which is claimed by the plaintiff. Defendant number one, respondents by of raising the said wall had actually encroached and amalgamated such and such of the land which is being claimed as breadth of the passage.
No, but her deed and her evidence says that the passage is in the eastern side.
Eastern side, but the schedule is said western side, and commissioners also said that there is no passage on the western side.
No, her plot is located to your eastern side. Your plot is on the west.
Western side, 1943 my plot. And the plot, which the passage is 1947.
1947, which is on the western side of 1946.
That is, boundary is also not given in the schedule, that is recorded. In the trial court judgment, just I read, that they said that boundary, it is boundary is also not given. But kindly comes to this. Okay, kindly comes to
reversal.
Just
pointed out to the division bench that question of law.
I thought
you admitted and you got
no. I served. I could not argue that I could not serve. But sometimes not the Honorable Justice Girish Chandra Gupta also you're not taking income tax matters like 100 CPC. But I used to direct us to serve the copy on the question of law. But we have to.
Second appeal is admitted and you can point out.
But I served pursuant to officer's direction. But that's the practice.
Appeal formally admitted. That's also.
Yes, my lord. That's why, I moved the Honorable Division by a single bench also. Now, the reversal, judgment of reversal, did not consider the commissioner's report to that aspect, and mainly consider the point of easement, although there is no easement right. Plaintiff did not claim that easement right. Plaintiff's claim is that as if she has purchased that passage along with 10 decibels. But the calculation shows that 350 passage cannot be within 10. And it is plaintiff's her own admission on statement deposition that the passage is on another plot of land, another person's plot of land, which is not plot of land, of my land. So there is
the
perversity.
Matter has been assigned before this bench under a peculiar predicament, full stop. Although the second appeal was formally admitted, double inverted mode formally admitted, inverted close, by a coordinate bench, vide order dated January 17, 2023, there was no formulation of any substantial question of law in the said order. Subsequently, the matter came up before a learned single judge at the time of hearing of the appeal, when vide order dated July 11, 2025, the learned...
Not hearing of the appeal,
Achha. For hearing of the appeal, single judge, when vide order dated July 11, 2025, the learned single judge pointed out that the that in such situation, the intervention of the Honorable Chief Justice was required. Thereafter, the matter was sent to the Honorable Chief Justice and has been assigned to this bench, apparently for formulation of questions of law. Learned senior counsel appearing for the respondents, rightly, points out that in view of non-formulation of any substantial question of law, the order dated January 17, 2023 is not a proper order of admission of appeal, and the appeal ought to be reheard under Order 41, Rule 11 of the Code of Civil Procedure. Next para. Heard learned counsel for the appellant. Upon hearing learned counsel, we admit the second appeal, and the same shall be heard on the following substantial questions of law. Roman 1, whether the learned judge of the first appellate court substantially erred in law in reversing the judgment of the trial court, thereby granting a decree as prayed for decree of declaration and injunction as prayed for by the plaintiff stroke respondents in the teeth of the description of the suit property in the plaint schedule being vague, coupled with the fact that the commissioner's report filed and marked as exhibit in the suit, as well as a report of the BL and LRO, clearly indicate that there is no existence of such of the suit passage as claimed by the plaintiff. Roman 2, whether in view of the gross discrepancy between the purchase deed of the plaintiff as well as the evidence of the plaintiff as PW1 to the effect that the suit passage lies to the east of the purchased property of the plaintiff, whereas the same has been described in the plaint schedule to be on the western side of the said property, the judgment of the learned appellate judge granting the decree is perverse. 3, whether the judgment and decree, whether the judgment of the learned first appellate judge suffers from substantial error of law, inasmuch as the learned judge came to the conclusion that the existing wall on the western side of the plaintiff's property was constructed by the defendant stroke appellant,
Defendant number 1.
defendant number 1 stroke appellant, without adverting to any material evidence on such count and stroke or without such evidence being adduced, adduced, full stop. Next para, the matter, the appeal shall now be placed before the learned regular single judge having jurisdiction to take up second appeals, subject to being mentioned by the parties.
The order of status quo already there. It was there, not status quo, but not to restrain the opposite party from raising on construction. Injunction applications.
We also revive the Mr. Chaturvedi, we are doing that.
We restrain the respondents from indulging any construction activities. That was there in the order.
What was the exact order?
We restrain the respondents from indulging any construction activity. They were raising the demolition.
We also revived the order. The restraint order imposed with the order dated January 17, 2023 to the extent that the respondents shall remain restrained from making any construction on the suit property. Till disposal, the application was kept pending, still pending.
Yes, pending.
Till disposal of Can 1 of 2022. You'll now mention the Can before the learned singular so that he can decide.
Milord,
and the user directions for filing paper books and
the formulation of substantial question of law in the presence of the respondent would not preclude the respondent from the rights preserved under subsection 5 of section.
It is at the time of final hearing that
the law.
No, since Milord, they have been formulated in my presence.
No. At the time of final hearing.
No, we recorded your objection that it has to be taken up as under Order 41 Rule 11. So Order 41 Rule 11 is governed by Order 42 Rule 2. So it's the first formulation.
And at
how
the
can
time of final
even if you formulate a question in your presence, Mr. Chaturvedi, you are entitled at the time of hearing to say this is not a good question.
Yes, subsection 5 says
this is not what
we need not put that in our order.
Mr. Chaturvedi knows very well at the
if
time
it requires to be Milord gone into in my lord's order, Milord, I was only proposing. I faced a difficulty, hence Milord, I come up with this prayer.
No.
It's automatic.
That should be the first of its kind.
I filed a caveat. I tell my lord, I filed a caveat.
Even then.
Milord, I filed a caveat.
We took it up under Order 42 Rule 11 that you have said.
Yes.
That's why you reimpose that order.
No, kindly hear me. I filed a caveat, Milord. I entered appearance.
Oh, in another matter?
In another matter. Milord, questions were formulated. The appeal was, Milord, then heard by a learned single judge. The learned single judge, when I said that I exercise my right under subsection 5, Milord, took up a point that this were formulated in your presence, you did not raise, so you have acquiesced your right.
The Supreme Court categorically says that you have a right, even at the time of final hearing. There's no substantial question of your access.
Do you want us to comment on this, Mr. Chaudhary? You can comment, but not here.
I was only, my lord, wondering if this was innocuous, would not in any way affect anyone, and yet preserve me from any apprehensions which I expressed.
That's
Code of Civil Procedure still remains. Judges change.
It will live beyond me.
CPC
Yes,
hopefully lives beyond judges.
Yes, yes.
But we don't know. Nowadays things are changing. So CPC may be scrapped someday for some other reconciliatory proceeding.
Not execution part is very blood. Execution part even.
Execution of the judge.
No, under the CPC. But not getting the fruit of the decree for years together. That should be amended.
That's true.
Nice one.
Yes.
Appear for the appellate. Not this pertains to not.
We'll release matters, Mr. Mujumdar, if it exceeds 100 pages.
Therefore, there are two matters.
Oh, Mr.
Therefore,
Bhattacharya is there, so it has to be commensurate with the
size.
The gravity of the.
But that's why there is a convenience brief for an aging
yes.
for an aging person like me.
Right. We balance out each other.
I'm not. Before we proceed further, it's my duty to point out to your lordship that on 15th July, the matter is otherwise ready. It has been assigned to your lordship's bench. On 15 July 2025, there is an order passed by the Honorable Division Bench presided by His Lordship Justice Showman Shin. But where an observation was made that since the matter was made CAV by a Honorable Division Bench of which Justice P.S. Chatterjee was a member, so the matter may be assigned to such bench, but the Honorable Chief Justice's court, on the administrative side, has been pleased to assign the matter to your lordship's court. So your lordship may hear this matter.
Should have been before some other bench.
No,
with Justice Showman Shin. Anyway, it's a Chief Justice.
His lordship did not hear.
Prerogative of the Chief Justice to master of the rest. But what is this? Against what?
No, this is with regard to not assumption of office of the post of headmistress in Kamala Girls School.
Kamala Girls School is government aided.
Yes.
It's still functioning.
One of the very few schools which is running.
Yes, when we passed the school, previously there used to be those puja and all.
Yeah.
Still function. Yes, any preliminary objection? That stage is over.
Objection. In fact, in this matter, I am in support of him.
Oh, so who is opposing?
Bari, today Mr. Bari is not here.
Surprisingly, who is opposing is
Kamala Girls School.
The managing committee of the school filed a writ petition challenging my posting in that school.
Mr. Mujumdar, should you give a notice and come back? I think that will be there. Otherwise, again, it will
be... had an independent writ petition challenging my posting, and I had a writ petition seeking implementation of the posting. Since my
you are the headmistress.
I am the headmistress who had been transferred to posted in this school.
Right.
Since my writ petition got dismissed,
regarding challenging the transfer.
No. Seeking implementation of the posting.
Oh, actually seeking.
Since my writ petition got dismissed, consequentially, Mr. Bari's writ petition got allowed.
No, your writ petition was dismissed. You have been transferred. You have been posted here.
But school didn't tell us.
School filed a writ petition challenging.
Why was it dismissed? You have challenged that dismissal.
No, I have challenged my
both.
Since there are two separate writ petitions, I have filed.
It was dismissed on what ground?
This was dismissed on the ground that the rules of transfer had not been followed.
But there was no challenge to that transfer order.
By Mr. Bari's client.
Oh, he had a challenge.
He had an independent writ petition. Since my writ petition got dismissed, his writ petition got consequentially allowed. And not the Kamala Girls School does not have an headmistress for the last 8 or 9 years.
And you are for?
I'm for West Bengal Board of Secondary Education.
Board has.
You have transferred.
Board and state
for School Service Commission.
Board commission.
Obviously, you will support because you have transferred.
Their action, yes.
At the time of call, none appears for the contesting respondent. The learned advocate in record for the appellant is requested to serve a notice on his counterpart, his or her, your advocate, his counterpart appearing for the contesting respondent, indicating that the matter is appearing in the list. The matter shall next be listed under the same heading on August 12, 2025. It is made clear that in the event none appears on behalf of the contesting respondent on the returnable date, the matter may be taken up ex parte in the absence of the contesting respondent. Please try to serve a server copy of this order so that this part of the order also goes.
And I'm appearing for the petitioner.
Pursuant for the state respondent led by Mr. Ghalib Lordship.
Right. This is item 9. It's a 9,
13.
9, 8, 9 হয়ে যায় 10 আচ্ছা ও তাহলে এটা কোনটা 13 আচ্ছা 13
No, I beg to represent the state.
right you have for the petition
Petition. Lord, a vesting proceeding was initiated against my the father. My father the transferred subject land prior to 7/8/69. So in that vesting proceeding was challenged before this honorable court. Kindly,
no you are the
I am the son of the big Raya.
right
Now against my father 14T3 of was proceeding in the year 1980.
এই ল্যান্ড রিফর্মস অ্যাক্ট একটু দিতে হবে ওয়েস্ট বেঙ্গল ল্যান্ড রিফর্মস অ্যাক্ট we'll have to brush up the law on this because we are long out of touch. Both of you will have to help us. Land Reforms Act generally yes, but
yes,
this particular branch we have touched after a long time.
Lordship knows.
No.
ওই যে সামনে আপনার হাতের কাছে যেটা
Land Reforms Act.
না আরো এদিকে
মাদিকে
Then may I hand over?
ওই যে
No, we have copies. Why should you take the trouble? And we have to keep this handy because in other matters also this will be regularly required. ওইগুলো তো আনিয়ে রাখতে বলেছিলাম না যেগুলো তার মধ্যে এটা তো একটা আজকে তো লাগবে এখন তখন কি করবো তাহলে উনি তো
transferred by my father prior to 7/8/69. So the land which are transferred prior to 7/8/69, that cannot be taken into consideration in a LR vesting. This is the settled law in view of the section 14P. Now 14P.
Yes.
Now since the state authorities the vested this land, a writ petition was filed before this honorable court. Kindly comes to the order passed in that writ petition, page 33. Page 33, kindly comes to page 35. In the recital, it has been stated bottom portion, order dated 26/8/80 for 37A case number such and such. Now kindly see this order. The honorable court held that the riot concern was holding the land below ceiling. They calculated the land which were transferred in the prior to 7/8/69. Now I accordingly set aside the was the impugned order. This is the order. The riot was the holding the land below ceiling. Now subsequently, the another vesting proceeding was initiated by the state authorities. My first point, the 7A cannot be reopened under the Amendment Act, or in case of further acquisition, state has a power to initiate another proceeding under 7AA or otherwise. The issue has already been settled.
Let us see 7A.
No, that is
14T3, 7 is the form, the form of retention.
7A if there is an
initial the vesting
yes
15 to 71.
Yes.
That will be considered in the 14T3 proceeding, and the riot was given opportunity to retain this land under 7 form.
All right.
Now here
once that exercise has been done, cannot be reopened.
cannot be
So what can be done? It can be revised.
revised after the Amendment Act 9880, 7AA, or the further acquisition of land. Now, in the year 2000,
Yes.
the another vesting proceeding was initiated.
Regarding the self-same land.
Because the self-same issue.
Now it has again been vested.
Against vested, that land was taken into consideration.
You challenge that before the tribunal.
Challenge tribunal said there is a provision for appeal. 54, we preferred an appeal. We preferred an appeal. Appellate authority now kindly comes to the appellate authorities. I am against the appellate authorities concluding part, page 63, bottom portion. From bottom, that they the vested 4.75 acres land excess to the prescribed ceiling limit.
So this covers that.
Yes, but the last portion is very important.
Yes.
But totally ignored the area of 6.03 acres of land transferred before the restricted period, that is 7869, which had also been mentioned in CR case number, that is writ petition, such and such. Honorable High Court passed the order, entire proceedings in contravention of the ceiling limit, the subject land. Now the order was quashed. Now against the appellate authority, the remand the matter to the prescribed authority. Now this is a simple the mathematics. They vested 4.75 without considering the 6.03 has been the transferred prior to that. So there is no necessity to remand.
It should have been set aside outright.
Now,
again, there is a vesting order.
This is the vesting order.
This is, you have preferred this challenge against the vesting order.
No, I have challenged
against the initiation of the proceeding.
The vesting order passed against the paper and appeal. This is the observation of the appellate authority.
Vesting order. That is the fresh vesting you have challenged before the appellate authority. This is the order. And you challenge this before the tribunal. Tribunal affirmed this.
Tribunal affirmed. So there is a provision.
Show us how the tribunal affirmed.
Tribunal, there is a provision for remand. So
no, nobody disputes there is a provision for remand. Mr. Ghalib's counterpart said that there is a provision.
The internal page 4, the observation of the learned tribunal.
Remand, prolonged delay. No, they didn't take into consideration the main aspect of the matter.
That fact was not the considered.
Take this point that this was previously decided and all.
Yes. In my OA application, kindly see, I have annexed this OA.
You argued this at the time of argument.
Page 31. Page 31, in the specific pleading is there.
So on both grounds, one is that previously it has been decided it cannot be reopened.
Yes.
Decided up to this court because this court had single judge has.
Yes.
And secondly, that even on merits, the same logic applies that this is prior to that 7th of August 1969. So on both grounds, it should have been quashed altogether.
The appellate authority ought not to have direct the prescribed authority to rehab afresh. There is no question.
What is the first authority's order? The first order which was challenging this appeal before the appellate authority?
This is page 37. Page 37 this order.
Where is the final order?
Final order as page page 49.
Yes. 8/4/2003.
8/4/2003.
Very well. Yes, Mr. Gali, what do you have to say?
My lord, my first reciprocal submission is, my lord, since, my lord, the order under before your lordships was an order of remand, just remand by the section 54 authority has been affirmed by the learned tribunal. And since it has been, my lord, affirmed, so, my lord, I should respectfully apprise your lordship the update from the instruction that we have already, I mean the prescribed authority BLLRO, in compliance with the order of the learned tribunal, has already fixed a date, served a notice upon the petitioners, and 13th August 2025 is the date fixed for hearing of, my lord, the proceeding.
We'll set aside this order, so that goes.
No, Lordship, kindly see. So now, my lord,
After
it
serving
is
the writ petition or the notice has been made.
my lord, this in my rescue submission is an innocuous order. Why, my lord? My lord, my learned friend is challenging that why the section 54 authority, upon quashing the vesting order of the BLRO, has demanded it. This is the plain and simple, my lord. My lord, he says that kindly sees the grounds. Kindly sees the grounds. He is harping upon kindly sees the grounds in the writ petition before your lordship. Why the learned tribunal is wrong? First ground, material irregularity. Kindly see my lord, page 12. Second, my lord, ground is in absence of any further acquisition of land, respondent authority have no power to initiate proceeding. It was initiated earlier. He challenged it.
3 and 4 are there.
Now, my lord. So this what my learned friend wants to say,
3, 4,
that
5.
why should I go on remand? But my lord, the statutory
Should have set aside outright. That is his case.
no should not have been. My lord, his case is my lord reason 1.
3, 4, 5 grounds.
Yes,
Page 13.
yes, his that is his ground. My lord, my first rescue submission reason 1 is that after High Court's order, my lord, in WP number so and so, fresh vesting proceeding was initiated in 2000.
Could it be? Because this has already been decided. The self-same plan.
No, but as per 14Y, lordship, and the book is not with me, it can be reopened. It can be reopened.
14Y.
Lordship, it can be reopened.
No, that's on a subsequent event.
Subsequent event.
Total area of land owned by the Rayat exceeds.
So what my learned friend is,
here the area remains the same. There is no case made out by
no, but
any of the...
when the PLRO opened the case, he contested thereafter. After losing, he challenged it before the tribunal. Tribunal first way. Tribunal says in the first way that why didn't you
relegated to the appeal? He went to the appellate authority.
Appellate authority.
Appellate authority decided remanded.
Appellate authority said remanded.
What is the question of
so
remand?
Remand, lordship, there should be an adjudication in my humble submission under section 54, since it is a statutory appeal, and my lord, without giving the appellate authority, the prescribed authority to decide on remand, it is permissible. My learned friend, it is not permissible. Section 57 of the Act.
He's not saying it is not permissible. He is saying that on merit it should not have been done. He should have set aside outright.
But he did challenge me, lord.
Cannot put something in his mouth. Not a question of authority to remand. Law permits remand. That means it has to be remanded.
No, since my lord, he is of the opinion, kindly sees.
Whatever may his opinion, his grounds 3, 5 are there.
No, section 54. Section 54 order, that is the order under challenge in the way.
Oh, the opinion of the appellate authority was saying.
Lordship.
Yes.
May I, my lord, respectfully read from a little earlier? My
hence, in these circumstances, what circumstances? It observes the previous High Court order, set aside, and then does not adjudicate, shirks its duty. Should have set aside outright.
No, after High Court's order, the fresh proceeding was started in the 2000.
Maybe could not have started. This is not a 14Y scenario, Mr. Galip.
No, 2000, the new
cannot be reopened over and over again. The same decision.
No, 14T proceeding was initiated on new grounds. Lordship, my learned friend has shown this.
He has acquired new property.
No. But the appellate authority also himself observed that that point was not considered for the region set aside. 4.75 was vested, but the appellate authority held the 6.03 was not considered.
But
so from simple mathematics,
only
it is below ceiling. That was observed by this Honorable High Court in the early proceeding.
But let him complete. Yes. Yes, Mr.
In the case of ceiling surplus land only, the big right will have to submit the return. Now, Miller, kindly sees page 63 in the appellate order of the under section 54. Miller, the big, let me just Miller read a little above, Miller Lordship, at page 63.
Yes.
That the handwritten that the erstwhile Rayat, Mr. So and so has been scheduled. That the had schedule of the erstwhile Rayat Kishno Kumar Mondol had been prepared and finalized a total quantum of land 22.05. So, my lord, this big riot on the basis of the schedule of land submitted by him, because schedule of land is submitted by those persons, those big riots who are having ceiling surplus land. My lord, 14 my lord, T says that. Now, my lord, since he submitted 22.5 in place of that so and so, so and so, so and so, now it is also mentioned in the order sheet that it is evident that with a deed number so and so 1969, the riot transferred the plot number so and so, so and so, and plot number so and so, so and so, as these transferred prior to date 7th August 1969. These plots are not taken into account in this proceeding. This is the observation of the BLLRO. Further, it is also mentioned that hence it is therefore ordered the lands of the riot in Maujas, namely 3 Maujas have been written here, are non-irrigated lands. Hence, as per provision section 14M of the Land Reforms Act, the riot having family members consisting 2 to 5 entitled to retain 5 standard hectares of land, that is 17.30 acres of land. So 22.05, that is the total land quantum of land mentioned in the schedule which was submitted by the big riot, minus 17.3, the non-irrigated land, acre 4.75 acre being excess of the prescribed ceiling limit are hereby vested in the state with effect from 5th February 1970. So this vesting part. But totally ignoring the area of 6.03 acre of land transferred, this is what my learned friend has read, my lord, before the this period, restricted period, that is 7th August, and is which had also been mentioned in CRK. So, this part was not excluded as per the observation of the my lord, appellate authority. So, my lord, the entire gamut, my lord, that the big riot submitted a schedule of land. Schedule of land is submitted by those big riots who are having ceiling surplus land, not for those riots who have ceiling below ceiling land, they don't have to submit the schedule. So these gentlemen submitted 20.05 as per that the calculation was made because his family member was 5. So thereafter this transfer part which was made to his son, grandson, all these things. So 14P was not taken into consideration by BLRO. So that has to be taken into consideration, my lord. So remand, my lord, it is an not open remand but limited on this point. So since, my lord,
yes, what do you say, Mr. Ghosh, that regarding the previous order of the writ court, it was just stated that purported to club the said land with other lands belonging to the writ petitioners.
I am placing the first order. It is submitted on behalf of the writ petitioner.
Yes.
That although the lands held by are the below the ceiling limit, yet the concerned officer has purported to club the said land with the other lands not belonging to the writ petitioner.
So this was the premise, not what you were saying.
No, yes, that is the writ petitioner. Kindly see that
it was those lands were transferred by you previously.
Yes, that land is taken.
Those are the lands referred to here as lands not belonging to you.
The land transferred by the big riot prior to 1769. The authority initiated the proceeding.
You had transferred the properties previous to that date, cut-off date.
Cut-off date.
So those were considered. That's why it is stated that land taking into consideration lands not belonging to you.
Others land, the clubbed with the writ petitioner.
So those other lands which you have transferred before
that cannot be the subject matter of this. That issue has been decided. My respectful submission, until unless the further acquisition the comes. So the state has no power to initiate further proceeding.
Unless?
Further land or further acquisition of land. So subsequent land, until unless subsequent land comes.
Yes, we are setting aside. We have heard.
Since pleadings have not been used, my lord, since this 50.
No, we'll record that now. All the documents are annexed here. Since no affidavits have been invited, it is deemed that none of the allegations made in the writ petition are admitted by the respondents. First of next para. In view of the relevant documents being annexed to the writ petition, the same is being taken up for hearing. First of next para. Learned counsel for the petitioner argues that by the order which was impugned before the appellate authority, the revenue officer came to the conclusion that the petitioner was holding land beyond the ceiling limit and vested the same, comma, without taking into consideration the fact that the petitioners had already transferred a part of the property prior to the cutoff date of August 7, 1969.
The predecessor interest of the petitioner.
Predecessor interest of the petitioners had already transferred a part of the land prior to the cutoff date of August 7, 1969, as per the contemplation of Section 14 capital P of the West Bengal Land Reforms Act 1955, and as such, comma, erroneously clubbing those lands to within the total land held by the petitioners stroke big rights. Full stop. Next para. Learned Counsel further submits that a previous exercise was done earlier, which was challenged before this court. Full stop. A learned single judge of this court, comma, vide order dated August 24th, 1999, passed in CR number 11376 within bracket W of 1980, comma, had set aside the said vesting on the ground that lands not belonging to the writ petitioners were clubbed along with their lands for such vesting. Full stop. Next para, it is submitted that in view of such exercise having already been undertaken once and culminated in the order of the learned single judge, comma, the self-same exercise could not have been initiated by recommencing a vesting proceeding with regard to the petitioner's land. Full stop. Next para, learned counsel for the state argues that the appellate authority was well within its powers in remanding the matter to the revenue officer. Full stop. Next para, moreover, comma, the remand order was in the nature of a limited remand, and as such, comma, there was no illegality or jurisdictional error in passing the same. Full stop. That apart, comma, learned counsel places reliance on Section 14 capital Y of the 1955 Act, which empowers the state government to recommence vesting proceedings in respect of lands held by big riots. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we come to the following conclusions, colon diye niche. Insofar as the power of the appellate authority under the 1955 Act, comma, in the exercise of its jurisdiction under Section 54 of the said Act, comma, there is no quarrel with the proposition that undoubtedly the appellate authority is vested with such power of remand. Full stop. Next para. However, comma, the question is whether the appellate authority was justified in so remanding in the facts and circumstances of the present case. Full stop. Next para, we find from the observations of the appellate authority itself that the appellate authority clearly took into consideration that the impugned order of vesting afresh was passed by totally ignoring the area of 6.03 acres of land transferred before the prescribed period, that is restricted period, that is August 7, 1969. Full stop. Next para. Furthermore, comma, the appellate authority took into consideration that there was a previous adjudication by the learned single judge of this court in CR number 11376 within bracket W of 1980 on the self-same issue. Full stop. Despite taking into consideration the same, comma, the appellate authority, comma, instead of setting aside the fresh order of vesting of the revenue authority, comma, remanded the matter unnecessarily, comma, contrary to the principle embodied in Order 41, Rule 24 of the Code of Civil Procedure. Full stop. Next para. It is clear from the materials on record that the reopening of the self-same issue is not permissible in law, comma, since there has to be an end to litigation and the principle of res judicata is applicable, comma, since the since a vesting proceeding is in the nature of a quasi-judicial exercise where certain powers of assessing evidence are exercised. Full stop. Thus, comma, the principle of res judicata is squarely attracted. Full stop. Next para. Inasmuch as the insofar as the argument of the state under section 14Y, capital Y, of the 1955 Act is concerned, comma, the said provision is applicable only in case of future acquisition of land by a Rayat, that is, if the Rayat acquires further land subsequently, comma, which is not the case of any of the authorities here. Full stop. Neither the revenue officer nor the appellate authority were of the opinion that further acquisition of land was done by the present petitioners. Full stop. As such, comma, there could not be a reopening of the same exercise by initiating a vesting proceeding for the second time, comma, thereby throwing open a closed chapter. Full stop. Next para, that apart, comma, in view of the specific order of the learned single judge dated August 24 to 1999 in CR হবে ওটা 11376 within bracket W of 1980, comma, the the revenue officer acted palpably without jurisdiction in passing the order impugned before the appellate authority, and the appellate authority had no other option but to set aside the order of the revenue officer instead of unnecessarily remanding the same to the self-same authority. Full stop. Next para. Moreover, comma, even on merits, comma, in view of the bar under section 14 capital P of the 1955 Act, comma, there was no scope of taking into account the lands transferred prior to August 7, 1969 to be included in the land held by the petitioners. Full stop. Next para. Thus, comma, the order of the appellate authority suffers from material irregularity and patent illegality. Full stop. Accordingly, WBLRT 113 of 2025 is allowed on contest, comma, thereby setting aside the impugned order
November.
No.
Yes, November
19 November 2024. Below page 67.
Yes. Dated November 19, 2024, passed by the West Bengal Land Reforms and Tenancy Tribunal, comma, 4th bench in OA 3292 of 2016, as well as the order of the appellate authority dated May 12, 2016, and the order of the revenue officer dated April 8, 2003, whereby the land of the petitioner was vested. Full stop. Next para, there will be no arrest to cost certain certificate.
But only one thing, since they are claiming the land vested, that is in Khotian number 1. Prior B, I prayed for the direction upon the respondent to correct their record of rights.
For that, you have to file a proper application.
Just observation, I shall file an application.
Liberty is given to the appellant. Liberty is given to the present petitioners to file a proper application in accordance with law for correcting the LR records of rights in terms of the above order. If such an application is made, comma, the appropriate authorities shall decide the same expeditiously in the light of the above observations. ল্যান্ড রিফর্মস অ্যাক্ট আনিয়ে নিন এক্ষুনি, 2 কপি এক্ষুনি আনিয়ে নিন, ওটা ওনাকে ফেরত দিন আর এটা নিন। Thank you. আমরা যে বইগুলো অতদিন আগে আনিয়ে রাখতে বললাম, আপনি দেখেননি এগুলো পুরনো বই, আজকে এখন যখন মামলা
My lord, in this matter, Mr. Shomik Ganguly is appearing on behalf of the Bankura municipality. Due to his personal difficulties, he is not present court today. Kindly make it not today.
What do you say?
My lord, there is nothing in the matter, my lord. My lord, what should I say, my
on
lord?
the prayer of learned counsel for the Bankura municipality, respondent stroke Bankura municipality, comma, let the matter stand adjourned for the day. Come back tomorrow. The affidavit of service filed today be kept on record. Please give your names, all of you. Please.
Great.
Deeply obliged.
Every euro file is fine.
I am on the plaintiff appellant petition, and this is a restoration application in connection with order 41 matter, my lord. On 26th February, it was dismissed. Within
Mr.
30 days, it was filed, my lord.
Mr. Chatterjee, what is the ground? Just for
Ground is, my lord, with regard to a peculiar thing. The property originally was of
no, not that. Only the ground of
substantial question of law. Oh, yeah. Yeah, my lord, it was our mistake. We missed the matter in the list, actually.
You have
That
not
is-
abused any advocate or something like that?
No.
Any judge?
Doesn't arise, no.
Then we will not allow. Mr. Chatterjee, we have probably been assigned this matter or what?
No.
This is for default by us.
No, by the Honorable Justice Harish Tandon and the Honorable Justice.
Oh,
Madhur
because you have order 41
Yes,
jurisdiction.
yes, order 41.
So should we take it up after that under order 41 also?
It would be better, I believe, my lord.
Very good.
because
In view of there being no representation on the part of the respondent at the time when the appeal was dismissed for default, comma, the principle of Order 9, Rule 4 of the Code of Civil Procedure, read with Section 107 of the said code, are applicable, and as such, prior service of notice is not being directed on the respondents. Full stop, in any event, comma, since the respondents do not have a right of hearing under Order 41, Rule 11 of the code, comma, such service is not required. Full stop. Upon perusal of the averments made in the application, comma, we find sufficient cause for the absence of the appellants on the relevant date having been made out. Full stop. Accordingly, can 1 of 2024 is allowed, thereby recalling the order dated February 26, 2024 and restoring SAT 228 of 2023 to its original file and number. Full stop. The matter is, the second appeal is now taken up for hearing under Order 41, Rule 11 of the Code of Civil Procedure. Yes. So we'll take up the matter now. So move the matter.
Your Lordship, kindly come to the ground, your Lordship will, my lord, get it. Just come to the ground, I have stated that itself is sufficient.
No, you just give us the
Matter is,
facts.
my lord, yes. Matter is,
You are
my
the
lord-
plaintiff.
Yeah, I'm for the plaintiff appellate.
Both
Judgment of affirmance.
Acha, yes.
Well, it originally belonged to the Jamindars. Now, from the Jamindars, by way of a deed of Amul Nama, my lord, our predecessor obtained the property. Now, at that point of time, he founded a school. In that school, my lord, he wanted to, by way of a deed of gift, to give that property. In 1957, we find a record whereby the vice president of the then, my lord, Board of Education, he made he gave a letter to the concerned school authority that within a certain date already there, you kindly get the deed of gift registered. Otherwise, we will not give you any recognition. Nevertheless, my
You
lord,
wanted to give the property.
my predecessor.
Your predecessor, right?
But the school authority, they did not, my lord, get any deed registered. Now, subsequently, the predecessor died.
concerned land was only 22 shatak out of 33 shatak. Now, my lord, naturally, the school cannot claim it to be of their own. I filed this declaratory suit because, my lord, some of the our properties.
No registered deed is there at all.
Registered deed. Then I filed the declaratory
Declarative
suit
suit,
there.
yes. And for injunction.
It was ex parte.
And for injunction.
Yes, and for injunction.
Ex parte dismissed.
Ex parte dismissed on the ground that the deed of Amulnama, although is there, but I find that there is only possessory title. Question is that, well, Lord, so far the Estate Acquisition Act and Land Reforms Act are concerned, only upon the possession it would be decided. Because of the fact, because it originates from Bengal Tenancy Act. The name of the Jamindars were there. Subsequently,
No, the Jamindars gave a patta to you.
yes, by way of a Amulnama.
Amulnama.
Amulnama
you have produced.
Exhibited. Yes, these are all exhibited documents. At this stage, my lord, both the courts, my lord, your lordship kindly come to the trial court, your lordship will get everything. Of course, my lord, one thing is there, that is when we file the suit, there, my lord, which also made a prayer, that prayer I am not entitled to get it. That is for correction of the record, because that is barred. So far, the declaration of my title is concerned, with regard to that, my suit.
No, correction of record.
In connection with what directly?
Consequential.
As consequential relief it will go.
Yes. Absolutely. This second appeal will be heard on the following substantial question of law, whether, in view of the predecessor of the plaintiffs stroke appellants having obtained the suit property from the Zamindar under the Bengal Tenancy Act, with specific recording of their names, of his name in the CS-ROR,
CS record, my lord, Jamindar's name, in RSROR, our predecessor's name.
In the CSROR, RSROR, the said right matured and ripened into full ownership over the suit property after the promulgation of the West Bengal Estate Acquisition Act, which was overlooked, which fundamental position of law was overlooked by both the courts below in dismissing the suit of the declaratory suit of the plaintiff stroke appellants. A defendant is not a owner of the defendant or not.
Defendant number 7, pro forma dependent.
No, the school was not directly declared to be an owner.
Contested, yes.
So this is the only ground where if you want to add, you can add at the time.
Since I didn't file any application for injunction because we are already in possession of the property. The hearing of the appeal may be expedited, my lord.
The appellants shall put in postal costs and requisites for service of notice of the appeal on the principal defendants stroke respond numbers 1 to 6. Regarding the others, should we dispense with? Or
yes. Only one is there. Prabhat Kumar Ghosh.
No, there are several.
He is with us, my lord.
Prabhat Kumar, yes. Right.
They are all.
And the others are plaintiffs.
Yes.
Okay.
Yes.
On the principal defendants stroke respondents 1 to 6 within a week from date, full of service of notice of the respondent stroke respondent numbers 7 to 20 is hereby dispensed with, in view of respondent number 7 being one of the pro forma defendants and respondent numbers 8 to 20 being co-plaintiffs with the present appellants in the trial court. Full stop, next para. The trial court record shall be brought by special messenger at the cost of the appellants, to be deposited within a week from date. The appellants shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to mention the appeal before the appropriate learned single judge having determination for inclusion in the list for the purpose of hearing, as and when the appeal is ready for hearing. Thank you. You actually copy pasted from your ground.
Yes.
Just rephrased it so that we have some
I heard it.
Yes. Thank you. 16.
It's my opinion. I appeal for the respondents. By the impugned order,
Yes.
but eviction has been directed in a writ petition along with my lord, a direction upon the principal secretary to appoint an arbitrator to go into the compensation for the part that I have been holding over the possession of the property. Now, my lord, there was initially a lease in 1980, which for a period of 16 years. It expired in 1996.
Right.
But from that time, I have been in possession. But I am a government department having vital machinery for tracking device of the motor vehicles, which is installed in this premises, about 4,400 square feet. My lord. Now, my lord, from 1996, I have been my lord, holding over the possession. I have been depositing rent with the collector, LA collector of the concerned area, my lord. And such rent about 45 lakhs odd, my lord, has been deposited over this period of time. Now, in the writ petition, my lord, first is my lord, I have been asked to.
Sir, Bandhavati, it was allotted to you or you purchased or what?
But it was a lease in 1980. Lease in 1984, but with effect from 1980 for a period of 16 years. So the term admittedly expired in 1996. From 1996 onwards, my lord, I have been holding possession over that till today.
But then you were an illegal occupier. No holding over case is made out.
No, holding over case has not been made.
Respondent number 1 is the landlord.
Is the, my lord, they first was Poddar Uddog was there, my lord.
But
thereafter there was a company amalgamation, etc. Then my lord, Mahorshi, which is respondent number 1.
Right.
They now claim to be the owner of the property, my lord, though there is no mutation affected in their name.
Right.
So we really do not know whether there was three parties, whether it was Mahorshi itself or not, my lord. One of the impugned orders in the writ petition has held that since there is no mutation, Mahorshi cannot come and claim to be the owner of the property. Now that has been, my lord, set aside. That order has been set aside. Now, my lord, if your lordship kindly sees, my lord, first I will take your lordship to the directions and thereafter, my lord, to the issues which has been framed. If your lordship kindly takes, my lord, internal page 20 of the impugned order, that has the directions upon me. Yes. Now, my lord, the time to my lord, give over possession has expired on 21st of July. Now, we are facing a special officer has been appointed, my lord, to execute the order, which is part of the order itself. Execution is part of this order itself, my lord. Special officer is there. Special officer is writing us, my lord, letters that I will come today at 4:30. If you do not give possession, I will come with police, I will take over possession, etc. We have annexed those letters also, because I think it will help my case as far as the stay of the order is concerned, my lord. Because if I am evicted today, my lord, nothing will remain in the appeal.
Your main ground, apart from that, in a writ proceeding, whether this could be granted?
There are two things, my lord, two major issues. First thing, yes, that is the first, but the
that
first
is a secondary issue, yes.
Yes, whether in writ proceedings I could have been evicted without going into the factual aspect, that is one thing. But at the same time, whether they had the right to sue against me after, in view of the operation of section 27 of the Limitation Act. I'm not really on the case of, my lord, adverse possession here. But, my lord, the question is whether by application of section 27, they had the right to oust me or not.
But can I have a copy of this in Limitation Act? So they came up after how many years? 12 years.
My lord,
96.
if my right expired in 96, my lord, they have come in 2012 at least. Second page. So, my lord, that is almost after another 16 years.
Limitation, and secondly, what is your other ground?
Other ground, my lord, for that, my lord, as I said, my lord, direction number 4 at internal page 21, which I am reading for your lordship's convenience, that the petitioner is granted liberty to submit a comprehensive application to the respondent number 2, Principal Secretary, Government of West Bengal, Department of Land and Land Reforms, seeking compensation for the period of illegal occupation by the respondent number 6. Upon submission of such application, the respondent number 2 shall appoint an arbitrator within a period of 4 weeks from the date of this order and refer the claim of the petitioner to the arbitrator
Thereafter, arbitrator shall proceed to pronounce such award towards compensation as expeditiously as possible. The amount directed to be received by the petitioner under clause 3 shall be adjusted against so and so.
They ask for mean profits. Mean profits they ask
But
for.
there is a prayer. But if
No, arbitrator obviously cannot be.
if it can be done by the arbitrator, my lord, the mandamus could not be issued.
No, arbitrator obviously, I mean, if unless there was an arbitration clause or
First
something.
of all, there is no arbitration agreement.
No, arbitrator we completely appreciate, but then
My lord, the question is, kindly leave aside the arbitrator, my lord. Who will determine the compensation? If the compensation can be determined by way of a civil fora, my lord, there is no public law remedy available to the petitioners. The mandamus could not have been there at all in the first place. The substratum is removed.
no, understand. We understand you have a better case on this 4.
But it will not help me if I am evicted and only compensation is left to be adjudicated
Right.
by this honorable division bench. But I am remediless.
But your status is a licensee. I mean, you can be evicted at any point of time. It's a continuous. Once you become a licensee, Mr.
The question, my lord, which I'll pose, my lord, for myself to argue subsequently, my lord, is whether, my lord, they had this right to sue
No,
after the effect of
why do you
section
say section 27 is applicable? Because there is no starting point of limitation. I mean, they can licensee can be evicted at any point of time.
My lord, when the time period expired of the lease from 1996, but I have been in possession of the property. It
There
is
is no
within,
scope of adverse possession because initially your point of inception, you were a tenant. So you could not have been in adverse possession. You cannot claim an adverse possession. You have not also claimed or proved
my lord,
adverse.
if I argue adverse possession, I will be in other difficulties because I am
Adverse
I
possession.
am a state authority. The
True.
Honorable Supreme Court has held in
Yes.
special decision from 2011 onward that I cannot set up a
No.
case of either as a sword or a shield. I cannot set
No,
up a
no,
case
no.
of adverse
And
possession.
that apart,
So, my lord, it is not really, my lord, the
licensee eviction at any point of time one can. Why? What is the starting point of limitation? The moment the
kindly
tenancy
take
ended.
Article 65.
Yes.
When the possession of the defendants becomes adverse to the plaintiff.
It never became adverse to the plaintiff.
So, my lord, throughout this period, my lord,
they chose not to evict you. But
yes,
that doesn't become adverse to them.
my lord, by choosing not to evict me, they allow section 27 to operate, losing their right to sue. It is, my lord, will not kindly treat it as my sword which I am trying to operate against them. It is rather, my lord, I am saying, my lord, here that whether they had the right to sue or not.
State's position could never have become adverse to them. It's not state, your state instrumentality.
State instrumentality. But, my lord, that is, I am not arguing on that line. But what I'm trying to say, whether they had the right to sue or not, whether they had this right to evict me or not. But there were other remedies available, other remedies which could have been there. They could have obtained rent. Ultimately, they want commercial exploitation of the
Facts are admitted because we could have relegated them. I mean, no use relegating them to civil suit because the facts are admitted otherwise.
But, my lord, there are other remedies which could have been explored if at all this order had to be passed, my lord. Ultimately, they want commercial exploitation, my lord. I am there. I was paying rent. They may have a
not a right you have, Mr.
But, my lord, it can be explored. It could have been explored, my lord, rather than evicting me in a writ proceeding.
No, that's absolutely their discretion, their choice.
But I am ready to give the market value. I am ready to give it has been done in Supreme Court decisions, my lord. I'll place it if required.
You don't have 142.
No, my lord, not in one. No, I'm not asking for a
If
140.
they don't agree to, I mean, we cannot compel them to agree to a mutual resolution.
But, my lord, in this process, I am putting across this
it can be
proposal to
sent to
them, my lord.
mediation.
But rather than, my lord, sending me letters by the special officer, they ultimately want commercial exploitation.
If you want that, we can keep it tomorrow and take instruction. At least the quantum can be resolved. Because this is obviously this is of some importance. The shifting of this would create some difficulty. But
I'll add to that. I have a live
necessarily
tracking
that
device.
does not. Your right does not go. You have a right.
I have a live tracking device. Your lordships will know, my lord, that now the commercial cabs have a alert system.
No, we'll give some time to you to shift for that.
But also they may take instructions, my lord, in the meantime, my lord, and I can come.
No,
back.
we will give some time if we affirm this order and then. And regarding the other portion, sending to arbitration, obviously we'll set that aside.
My lord.
Kindly hears me out, my lord, because this has been
No,
done.
right now, definitely, without hearing.
This entire order has been passed on the basis of a judgment of the Honorable Supreme Court. I will place my case, my lord. I have something to add, my lord, which Mr. Bandyopadhyay perhaps has not been instructed. From the records, I will
Like,
show you.
just indicate.
My lord, your lordship, can you take the memo of appeal? It is not a case of eviction, my lord. The lease had expired in the year 1997. Then they come out with requisition of the property. Writ petition is filed. In 2001, that requisition is set aside and the direction is passed vacate and hand over possession, my lord. This is the background of this case, my lord. They do nothing. They hold my property. They file an appeal. All parties are under an understanding that the appeal is pending. In the meantime, they get an order of stay from the Honorable Appellate Court. Appeal is dismissed for default. Entire issue is res judicata, my lord. This has been decided. Now, my lord, when we ask them,
No, but dismiss for default, not res judicata, order 9 rule 9 principle.
yes, my lord. I stand corrected. Single bench's order is, my lord, final, my lord. Your lordship will kindly take that order once. Everything has been decided, my lord. They still hold on under the requisition, which also lapses under Section 10B of the Temporary Requisition Act. Maximum period is 25 years. They keep holding on to my property, my lord. On these backgrounds, this writ petition has been filed and an order has been passed that on the basis of the judgments of the Honorable Supreme Court, you cannot do this. Requisition cannot be used as
The papers which have been annexed are sufficient for hearing this appeal.
Yes, my
for
lord.
hearing this,
My
this
lord,
appeal.
your lordship will kindly.
I have also prepared a short list of dates, my lord, since
Mr. Bandyopadhyay will just stay the operation for 7 days. We'll keep it tomorrow for hearing. Come prepared tomorrow.
But
And to also take instruction in the meantime. If you want payment, take instruction. Why not? Why not?
I go to the extent of present market value.
Yes.
Instead of tomorrow, can it be day after tomorrow?
Day after tomorrow, because you need some time to take instructions. Disruptive file on the time of hearing. Keep it with you.
Only one thing.
File at the time of hearing so that a prima facie case for hearing the appeal on merits has been made out. Full stop. However, in view of the short conspectus of the appeal, and since the relevant papers are annexed to the writ petition itself, further affidavits are not being directed, and formal and preparation of formal paperbooks are dispensed with. Full stop. Next para. It is deemed that none of the allegations made in the application are admitted by the respondent. Full stop. Next para. Learned counsel appearing for the appellant floats a proposal as to whether the respondent number 1 is agreeable to a mutual resolution by retaining the petitioner, retaining the appellant in possession on condition of the appellant paying the current market rent. Push up next para. Learned counsel for the respondent number 1 shall take instruction from his client on such count by day after tomorrow. Full stop. Next para. The appeal shall be heard on the present papers on August 7, 2025, when the same will be listed under the same heading, with the understanding that the appeal itself will be taken up for hearing. Affidavit of service filed today be kept on.
Grateful.
Grateful. Along with the stay application, sir. There was a connected stay application or
So, my lord, there was a delay of 49.
49.
And one is, my lord, for condonation of delay.
With a delay of 49.
Acha.
I'm
Thank you.
I could have pointed.
Oof. Nowadays you take us for granted so much that
I'm sorry. It is my mistake.
No, not us for granted as such. I mean, the Section 5 condonations for granted. That is what it is. Acha, এর আগে একটা add করে দিন, in view of this, what is the, you have not abused any advocate or judge or
He's abused the department for red tapeism, my lord.
since sufficient reasons have been shown for the delay in preferring this appeal, the can such and such is allowed, thereby condoning the delay in preferring the appeal. Full stop. The appeal is taken up for admission hearing. Full stop. The appeal is admitted. Full stop. তারপর যাব লিখতে।
Grateful, man. Grateful.
শুনানি হয়ে যাক একটা।
But very old matter. Look, there were defects. The defects have been rectified to some extent.
Still shown, to some extent is a,
Lordship, it permits me two parties were there in the court below who were not added party in this appeal. In the
appeal.
Lordship gives me leave below to correct it and move it next week because that defect still there. Three other defects have been removed by the order of Millard, the Honorable Single Judge sitting in the revision and teacher.
but then that appeal will be time-barred against those people.
No.
Anyway, since we are not on technicalities, we'll give you leave.
Title appeal, main parties are four
And
parties.
the appeal has been filed, so we'll be lenient on that.
That view, Lordship permits me and move it next week. There's a point for admission regarding Millard, the employment question is concerned. Now it's statutory held by Mahanadi Coalfields and other judgments.
Regarding?
SC Chandra. SC Chandra, I am holding Millard.
What is the point?
Millard, the point is Millard, the plaintiff was given Millard. These are Millard aided school run by ECL.
Should you take up the appeal for order for your hearing and give you that leave?
Correct it and move it, Millard. That is the best option to
Very
do,
well,
Millard.
very
That I have
well.
done from the court not to do it. Justice Tandon wants to don't try this because this will be the one of the point taken final. So it's better do all the correction, move it before.
Very well. On the prayer of learned senior counsel appearing for the appellant, comma, a leave is granted to the learned advocate and record for the appellant to rectify the memorandum of appeal by incorporating the names of all the parties whose names featured in the decrees of the courts below. First of next para. On the prayer of the appellant, the matter is adjourned for such purpose. Till when should he put it?
Millard keeps it next week because the executing court says Millard, they will take up the matter. 2 weeks time has been given to.
So
If
next
I
Monday?
succeed, I succeed. Next Monday. Succeed, I feel like.
On August 11, 2025. লিভটা দিয়েছি ওরা মেমোরান্ডামটা কারেক্ট করে দেবে।
This is the difficulty of bifurcation of the district. The files Millard, Bardhaman and between Assam.
পূর্ব, this is পূর্ব পশ্চিম.
Pashchim Millard got Millard misplaced.
Very difficult. Oh, you are the Eastern Coalfields, right?
Much.
No, we are suffering from regarding court records also.
And when they came to me, I said this is a matter which was admission or worth hearing at the admission at least. Lordship, it's up to. I don't say that's a wrong sentence I use.
No. We understand. Obvious. Yes.
Wait.
Next.
Not 89 for the respondent, my lord.
Respondent.
Yes, yesterday also not appear petitioner, my lord.
They're not appearing regularly. Who is appearing? Pranab Kumar Das.
Pranab Kumar Das.
You know him?
I don't know, my lord.
You're saying you don't know to get it dismissed for default or actually you don't know?
No, I don't know. my lord.
Dismissed for default, again they'll come and we'll give them a last chance.
Yes,
This is the second occasion act order. This is the second occasion. This is the second occasion when none appears for the appellant, although the respondents are represented through counsel. Full stop. Let the matter stand adjourned for the day. Full stop. However, comma, in the event the appellant fails to be represented on the next occasion when the matter is called on for hearing, comma, appropriate orders shall be passed in the absence of the appellant.
Item number 19.
My lord, item number 99, appearing for respondent number 4, my lord. My lord,
Respond.
on the previous occasion, your lordship granted us liberty to use an opposition against their, my lord, they intended to file a supplementary, my lord, supplementary.
I
affidavit. My
am
lord,
on behalf of the 5, my lord.
My lord,
Respondent number 5.
they have only served the copy yesterday, my lord. At very late hours of afternoon, my
Why,
lord.
Mr. Bhattacharya, this sort of
After 4 p.m. sir.
why?
No control, my lord, not my.
Yes, my lord.
So we'll give you time till when? Tell us.
At least, my lord, 2 weeks.
1
time.
week, my lord.
2 weeks for reply. But
My lord,
I tell your lordship, my lord, my
1 week is more appropriate.
Order 710, Millard, my suit has been Millard returned back. Now, Millard, that now there was an interim order. Now, Millard, that
Appeal has been admitted.
No, only section 5 is there, Millard, only 40 days delay.
My
That
lord,
they are
We have
my lord,
made the objection. We have made the objection. Opposition to the original application which is ready, my lord. If your lordship. can-
Opposition will take right now.
Yes.
we will,
My lord,
it has been
a
served
bare,
upon us
a
yesterday,
bare
Millard.
glance, my lord,
Oh,
It has been served upon us yesterday since it was the returnable date.
my lord,
We could not
I am
use
appealing
reply.
for,
I also want to file the opposition against supplementary. Just yesterday served.
the
up.
time for filing affidavits in opposition to the supplementary affidavit is extended for a week from date. Full stop. the appellant shall file their reply to the affidavit in opposition filed on behalf of the respondent number 5 today, also within a week. First of next para, let the matter be listed under the same heading on August 13, 2025.
Much obliged.
Come back after 1 week.
My time to file reply to that opposition of respondent number 5 be also extended.
Reply, yes, we extended that, we granted the time for 1 week also.
Very
That is the second portion.
Will.
First portion is opposition to supplementary affidavit.
My lord, opposition to supplementary affidavit by the respondent number 4,
4 and
my
5.
lord.
I want
একবার অর্ডারটা পড়ে দাও তো সুপ্র কি বললাম affidavit in opposition to the supplementary affidavit is extended for a week from date. তারপর within a week from date. Oh, you will have to file the reply to that.
That was why.
আচ্ছা আরেকটা লাইন তারপর অ্যাড করে দাও. The appellant shall file their reply to the affidavits in opposition filed to the supplementary affidavit within a week from the filing of such oppositions. Full stop. Returnable date যেটা করলাম 13 না করে 20 করে দাও. 20th August.
My lord, on the last occasion also granted us liberty to use our affidavit against the stay application, my lord. That may be extended, my lord.
That then it will be deemed that the appeal, the misappeal is admitted.
My lord.
Not right now.
That would not
Keep
be.
those prepared, and if you admit the appeal, immediately thereafter you can file those so that you can give advance copies. We intend to use these opposition if the appeal is admitted.
My lord.
We have all annexed, that those would not be necessary because we have annexed plain treaty.
Then we'll deem that there is no, you are not admitting any of the allegations made in the stay application.
This is order 7 rule 10 only.
Yes, what application, what opposition you will use?
My lord, the matter concerns regarding a property.
We may decide the entire appeal, but we don't have the determination now. That is one of the other reasons we are adjourning it. Because now another bench has determination.
My lords, those matters, my lord, are going to the other bench, my lord, as of now.
We have to now admit and send that to the other bench. But these appeals can be decided at the outset threshold. Either way, either you win or you win. Anyway, let us come back.
Much obliged, my lord.
This is the second occasion when none appears to move the condonation application. Full stop. Accordingly, Can 1 of 2024 is dismissed for default. Full stop. Consequentially, SAT 97 of 2024 is dismissed as time barred. Full stop. Can 2 of 2024 is accordingly dismissed as well. No address to cost. Ashok, restore করবে যখন তখন বলবো রেস্টো করলে বলবো যে হ্যাঁ ইমিডিয়েটলি কপি সার্ভ করেছো এটা শুনে দেবো অ্যাডমিশন শুনে
Item number 21.
This is the second occasion when none appears for the appellant. Let the matter stand adjourned for the day. As a last chance to the appellant, যা বললাম তো adjourn for a day, as a last chance to the appellant to move the matter.
Item number 22.
I appear on the appellant, my lord.
Yes, Mr. Bhattacharya.
On last
I'm for the
occasion,
respondent.
Sorry, last occasion?
My junior submitted that the parties are attempting to a settlement, my lord.
Achha, very well.
3 weeks after, my lord.
Learned counsel for the parties submit that the parties are exploring options of settlement between themselves. Full stop. Accordingly, on the prayer of the parties, let the matter stand adjourned till 26th August till August 26, 2025. Just 3 weeks.
Majo.
I'm for the appellant. The defendant appellant judgment of affirmance. There's a suit for eviction.
What is the defect? Apart from the defects on merits, some other defect also. Let's see. Certified copy of trial court. Not given. So they cannot ascertain whether court fee is correct. Certified copy of the trial court is
Decree.
not. Trial court, judgment and decree. Photocopies have been filed. Let us check up also. Appeal court is there. Trial court, nothing at all. Okay, check up what is missing once. Hey, একবার ওনাকে দিন তো। অনিদিন একবার শোনো একবার। Probably it's not there. So copy of trial court decree is probably there. We just miss. Just check up. What happened, Mr. Mukherjee? Too late. Which matter?
Previous matter. I'm for the respondent.
Previous matter, it was submitted that there's a talk of settlement going on.
I didn't know. I'm for the respondent.
You're
My
there.
name is on record.
If you did not know, you should have pointed out that you have no instruction.
I have no instruction on that, my lord.
Because you did not object to that, we put it after 3 weeks.
They told that there was settlement was going on.
Anyways. So adjourned till 26th August for exploring options of mutual settlement.
I was not, my lord. I'm obliged. I was not informed of any settlement before.
No, in future, if you are not sure, you say that I don't have any instruction.
No, Lordship, there was a settlement
He
going.
must be knowing. I was not told. He's my advocate on record.
Well,
I'm
you
not.
would have told your senior then.
He's not told me.
Just now, my senior has come, Lordship. That's why.
I'm sorry, man.
They've had a conference, Mr. Mukherjee.
I'm ready with the matter. I thought the matter is contested.
The report,
Yes,
it
Mr. Vada.
says me the report of sufficiency of court fees.
No. See the stamp there. But that's a default stamp.
Will be furnished on verification of valuation.
No, see not the handwriting, the stamp.
Yes, my lord, this is the stamp, my lord.
No, the above, the one above.
No, not in.
That is the main
certified
report.
copies of the judgment of the trial court. The judgment and decree could not have been filed with the memorandum of appeal. Name of
That is the reason for their not being able to calculate. You are in this matter.
No, my lord, I am being requested by this person, my lord, that Mr. Anirban Bose is representing, my lord, the respondent.
Order 41 matter, don't have a right of hearing. In any event, probably we don't know whether we can take it.
But this is there.
Certificate copy is there.
No, this is a photocopy.
Photocopy? Where is the certified copy?
Certified copy 23 file.
This is a photocopy.
So this is a photocopy.
You have to file the certified copy.
Yes.
File it within a week. We'll take it up after a week.
Will take it back from the first appellate court, then will
Take it. That will take a 1 day. Which court?
Howrah.
Which court?
Howrah. Yes.
Howrah. It has to be just taken back from the appeal court, not a new appeal. Very well. The appellant shall file the certified copies of the trial court's judgment and decree within a week. Let the matter stand adjourned till August 13, 2025. Please tell the gentleman of this order. He's the other side. Yes.
Order of remand, estimate.
Oh.
Let me not today, man. Why this evening, well, something may.
Oh, you have taken information?
No, today, well,
No, we don't. Are you sure?
Today's chief justice is sitting my yesterday.
No, that doesn't mean. I will keep it just next week.
But it will be not today.
Very well.
Both 24 and 25.
25, I am here, my lord.
No, we do. We are in doubt whether we have.
I have heard from Mr. Sen that my lord has
You are
expressed.
not taking any steps. You are not doing anything on that count. You are the leader of the bar, and you are
I
not.
have to take steps.
You have to take steps. Yes. So you have not yet taken any steps. You have heard but not taken steps.
But I have heard, but thereafter the chief justice, honorable chief justice was not available. Today I am not available. I am
Achha, right. So let the matter stand adjourned for the day, on what ground?
Just not today, madam.
Azhar ki record
at our prayer.
No, Mr. Basu will not record anything. We'll just.
Yes. But 25 is some urgency is there. It is a old club going to be followed.
I'm for the respondent.
No, you are saying
I'm
24 and 25 both.
Yes, 25 is some urgency.
25 FMT, my lord.
FMT.
You are appearing.
He is also appearing for one of the defendant. I am defendant appellant.
You are for the respondents.
I'm for the respondent. And 25.
He is the plaintiff respondent. I am the defendant respondent.
No, who is the contesting respondent? You are the contesting.
I think, my lord, there will be no contest. I'm giving 1 minute time. May I take your lordship 1 minute time?
Mr. Onir.
Wadi Athletic Club.
And 24. I am also.
They are asking for time, Mr. Basu.
No.
Yes.
Let her listen to me and can communicate. My lord, this club was established in 1898. My lord knows that Wadi Athletic Club is the oldest club than that of my lord in East Bengal.
Club?
What happened, my lord?
What club?
Wadi Athletic Club. Wadi. Is one of the anything with my lord?
25 or 24?
25.
Pradeep Kumar Datta to. Wadi
25. He's 25.
Yes, Pradeep Kumar Datta, 25.
Wadi, where does Wadi come in?
Yes.
No.
What are the athletic club, my lord?
Registered club, my lord.
Wadi is not even named here.
No, we are for the defendant appellant. They internal fight, as my lord knows, in every club there is fight. What we are paying, my lord, in 2017 last election held. 2019 it terminates. Thereafter, my lord, COVID came. We could not do anything. When we give a notice for running the show of the club, they challenge that. I want a committee to be formed by the my lords, and they will decide, and election should be held and will be continued.
So get an idea of their stand. Come back. We don't know whether we have determination to take up. Determination to take up, only not to take up.
My lord.
It's again
But
changing.
tomorrow, Mr. Sen, we don't know whether by tomorrow it will be resolved.
But let it be not today. Let us take it. Let us try, my lord.
And I am the plaintiff, my lord. In
No, exclusive jurisdiction of misappeal has been given to Justice Sen's bench.
That's the I have not something missing.
What one has given to us? It's obviously, I mean, this same glitch happened when Justice Sandon was there. So Basu, remember?
Same. But tomorrow I will be in court.
Hearing, he had rather the other way around. He had order 41 hearing. We had
No, it cannot be. But tomorrow, if I am in court, I will certainly, if it is not resolved, I will try to resolve it.
Not today only.
24টা হবে না এফএমটি গুলো জজ সাহেব নেবে না এফএমটি কেন ওই ডিটারমিনেশন একটু গন্ডগোল আছে ওই কারণে রিমান্ডে
বলে দাও যার জন্য দাঁড়িয়ে আছে আর কোনো আশা নেই কি করছিল